What's up, everybody? What did we just witness in the Young Thug trial? I that wasn't didn't go quite as well as I think the DA was hoping. They're on a break now until what they said 1:45. So that's 10:45 my time, West Coast time. So we got like an hour and 15 minutes until they come back and finish the opening statement from the DA, which I don't know if you guys are paying attention or watching the stream yourself, but it's kind of a disaster. It's kind of amazing that they've had a year to prepare for this trial. And the big problem right now is the DA was putting things up on her screen in the slideshow for her opening statement that the defense attorneys hadn't seen before. And she was supposed to disclose everything. So they objected. And apparently one of the slides they're saying actually had some information that had been barred from trial about like a previous conviction for murder that one of the defendants had. But the DA was, of course, objecting to any kind of mistrial, but she did say that, oh, maybe we could do a curative instruction here, which is some kind of extra instruction to the jury about, kind of correcting something that she just said. So to have this all going on, just like, 20 minutes, 30 minutes into her opening statement, I mean, it was just like kind of a shit show. It was like, haven't they been preparing for this trial for like a year? I haven't been all too closely paying attention to all the jury selection and motion trial stuff, but I have a little bit here and there. And the judge always just seems like super irritated and was like yelling at everybody. And sometimes when you have that kind of judicial temperament, they're like masking other like managerial problems or something. But it just seems like the DA kind of had some missteps in preparing for the opening statement. But it reminded me of a judge that I follow in LA, an LA federal judge who actually did Vanessa Bryant's lawsuit against LA County for the Kobe Bryant crash photos trial. The judge who oversaw that is really known for his like pre-trial stuff. So he has all these like overburdensome requirements for the attorneys to like, they have to submit everything, like every witness exam that they have to submit all the exhibits for it and say what their main points are going to be ahead of time. And all the attorneys are like, wow, this is so much stuff to do ahead of time. But the reason he does it is so that you don't have incidents like this happening where the jury is just they had like 30 minutes of action and then they're just pushed back in the jury break room and they don't really know what the reason for the break is. And of course they're all just twiddling their thumbs back there, and then they come back out, and he like acts like he's doing them some big favor by sending them to lunch, because what else is he gonna do? He has to kind of keep that telling him not to eat carbs for lunch. That was kind of funny, and really, I mean, it's kind of out of his hands at that point, and he's just trying to like make it as like humorous and whatever form as possible. But imagine being on a jury and like people are acting like you should just be so thankful that you get to go eat lunch. And when he says that he's not buying them lunch, it's like, well, you know what, maybe the court should buy these people lunch if you're just going to bring them into court and waste their time like this, because you guys are just treating this like another day in court, but these people are getting their lives like completely interrupted, and they're going to get like 30 minutes of proceedings. But here, I'll bring up some of the videos from earlier. I had to tweet that I was pretty stunned by this statement from the DA. I mean, I thought this was just like clear burden shifting. When she started, I was kind of like, get the screen going here. When she started saying it, I was like, it's just like, I'm almost objecting. And then, the objection came pretty fast from the defense. But here, let me share it. It's where when she was talking about the proof that you would see, or the evidence that they're going to see, because that's the point of opening statements, is you're not arguing anything. A lot of people call them opening arguments, but you're supposed to state what you think the evidence is going to be, and that's going to come in through exhibits and witness testimony. And then closing arguments are when, now that the evidence is all in and the testimony is in, you argue what it's supposed to show. So they're not supposed to be arguing anything in openings. But this right here, I thought was just like kind of stunning to hear her say, to the point I clipped this out and sent it to some of my lawyer friends, just because I know they'll watch it and just be like, wow.
You will not hear what you will not hear any evidence of is that the defendants were not involved in a criminal street gang.
That right there is just like, wait, what? I mean, and right when she said what you will not hear any evidence of, it's like, whoa. Stop talking right there. Like, because the defense doesn't have to prove anything. I mean, it's not on the defense to prove or disprove anything. The burden of proof is totally on the prosecution. And if she, I mean, statements like this made in closing argument could lead to convictions being overturned. But it's kind of stunning how she just goes on. And I could kind of hear a murmur right when she said it. Because, I mean, really, the second she starts saying that, it's like, whoa, what is she talking about? She can't be doing this. And you could kind of hear a murmur, and it's probably a defense attorney. But they speak up pretty fast. Because remember, there's 6 defense attorneys back there that can all lodge objections. But
you will not hear any evidence that they did not commit crimes on behalf of YSL.
Because they don't have
and as I stated to you earlier, what I'm saying to you now is
let me object to that statement, please, as burden shifting.
Object basis.
Yeah, and it is kind of surprising that I mean some judges might just intervene without an objection and stop her from saying that, but she just seemed kind of, and then sometimes that's like the typical reaction for attorneys when there's objections, like, oh, here we go again, another objection. It's like, no, that's actually like a completely reasonable objection. So I was like, okay, that is really not a good sign for like the strength of this prosecution, because I mean that's why this case is interesting to me, because it's one of those cases that when you hear about the indictment, you kind of know that it's just going to go to trial, because it's not just a cut and dry case like a first-degree assault charge. There was a shooting. Was there a shooting or not, where it's like the defense isn't that complicated. Like a racketeering charge, like trying to show that Young Thug was like in charge and like directing all this illegal activity. It's kind of this inherently subjective thing where, I mean, you can always kind of see jurors having like different views. I mean, there's a lot of like room for the defense to work here. So to have the DA like right out the bat, like making like such a, I mean, I just saw it as a clear, like why, what DA on earth would say that in an opening statement and think that it was like an okay thing to say? Like that is the kind of burden shifting that leads to convictions being overturned. So if you've got the DA like already saying stuff like that, it's like, oh God, I don't know how this trial is going to go. I mean, what they were saying, it might go on for like a year or something. That's a crazy amount of time, but six defendants. I mean, it took them almost a year to get the jury seated here. But I mean, really, let me pull up the rest of her opening here, because I like that's Brian Steele here is the defense attorney for Young Thug, and he's a Atlanta-based lawyer. I guess has done a lot of high-profile cases. I can't name any other defendants he's represented off the top of my head, but this is pre-trial, pre-opening today. They've all got headsets at the defense table, so they're able to listen in. But Young Thug is a little dressed up today. Last week he had a sweater on. They had him there. The schedule for these hearings, they had him in court until like 9:30 p.m. during their last hearing or something. And when you watch these hearings, they don't seem very sufficient, it's and then to have all that like year pre-trial stuff and to have this like go on, I mean, how long was the opening statement until we had like 20 minutes of an opening statement, maybe 15, maybe 20 before it got interrupted. I mean, it was like, seriously, people can't do anything. Guys can't do anything right. But here, let's beginning, somebody else brought this up that it just it made them uncomfortable that there were all these references to the jungle and wolf pack and stuff. It just seems like we're playing into stereotypes about criminal street gangs here. But I'll play it for you if you guys happen to see anything, and I'll go through some questions here.
But the wolf that shall break it. as old and as
There
true
we go.
as the sky. And the wolf that shall keep it may prosper, but the wolf that shall break it must die. As the creeper that girdles the tree trunk, the law running forward and back. For the strength of the pack is the wolf, and the strength of the wolf is the pack. Thank you so much, ladies and gentlemen, for being patient. Thank you so much for being honest during this very lengthy process that preceded this point here today during the voir dire process. I appreciate you all being here, exercising your civic duty.
It's pretty standard.
Honoring your obligation
Thanking the
to
jury.
pay close attention to what's going on in this courtroom for the next several, however many weeks.
I always cringe when this happens. Like, just get into the
Some people like to say that opening statements are a roadmap to what the trial will show. Instead, I'm going to give you an overview, a bird's eye view, because you're going to be sitting here with evidence for the next several weeks at least.
Get into the evidence.
And you will be able to see what that evidence is. Nothing that I say to you during this part of the trial, and nothing any other attorney says to you during this part of the trial is evidence.
I always find this so
But
unnecessary.
I can tell you,
Jury. Like they're
what I
already
expect
told
the
this.
evidence
Just
to
get
show.
into your case. Like
And what I expect the evidence to show in this case
here we go.
is that YSL, the group made up of the defendants sitting before you today, along with other both indicted and unindicted co-conspirators, YSL operated as a pack. The quote that I read to you earlier is from one of my favorite books as a kid, The Jungle Book.
It's a
In case
story.
anybody recognized it, those were Rudyard Kipling's words and not mine. But they are appropriate for where we are today.
Yeah, so somebody in my Twitter
For
reply
10
brought up
years
that it
and
made it
counting.
uncomfortable to have that kind of
The group calling itself
jungle
Young
references and
Slime
wolf pack references in a gang case.
dominated
Black people. It's like, are we playing into stereotypes
the
here?
Cleveland Avenue community of Fulton County. They created
Double screen action going on here.
in the middle of Fulton County's Cleveland Avenue community that sucked in the youth, the innocence, and even the lives of some of its youngest members. Now, the evidence is going to show that this group started out as a group called Rock
Yeah,
Crew.
trying to show it's just
And
it's a
Rock
really
Crew
big case.
stands for
It's not cut and dry like a first degree assault case. Was
The
there?
evidence is going to show you that Rock Crew
It's just
in
it's
fact,
subjective. And
is a criminal
mistakes they've
street
already
gang.
made don't bode well.
It's not the kind y'all are used to.
Listen,
If you're more familiar with the national gangs, such as the Bloods and the Crips that operate in LA or in Chicago. But make no mistake about it, Rock Crew is and was a gang. It consisted of 3 or more members with common identifiers, signs, colors, linguistic choices that committed crimes on behalf of and in furtherance of Rock Crew itself.
I think she's going a little too slow.
That particular organization aligned itself under an umbrella
Yeah,
of
yeah.
a larger, more
The jungle and the
traditional
wolf
street
pack
gang
thing was like, ugh.
called Sex,
Really?
Money, Murder, Bloods.
It's 2023.
They adopted the nomenclature. They would do things like replace C's in words with the letter B, because traditionally Crips and Bloods were not aligned with one another. So Cleveland Avenue became Believeland. Some of you may have indicated during voir dire you've heard or are familiar with the Cleveland Avenue area. Maybe you've even heard of Cleveland Avenue Day. The evidence will show that this is where that comes from. The evidence will also show that sometime in 2012,
super predators kind of thing,
or thereabouts,
yeah,
an internal rift or divide occurred among the members of Rock Crew. Now, the defendant, Jeffrey Williams, seated back there yawning right now, he was an original member of Rock Crew.
Jeffrey
And
Williams,
the kind of crimes that Rock Crew did consisted of smash and grab burglaries, stealing ATM machines, things of that nature. When Rock Crew split up, YSL, or Young Slime Life, was formed. And the defendant, Jeffrey Williams, was its proclaimed leader. Young Slime Life came about and consisted of 3 or more people when it began. 3 or more people who were willing to, and who did, commit criminal street gang activity, that is crimes, that were intended to further the purposes and advance the directives of YSL itself. Now, there will be no evidence of a written contract or anything like that. You won't see bylaws of YSL, because this was a group of people associated in fact, who used common identifiers, common names, common colors, common symbols to communicate with one another and to express themselves to the rest of the world. So YSL, as the evidence will show,
again, speed it up.
they didn't move individually. The members and associates of YSL, they moved like a pack, with the defendant Jeffrey Williams as its head.
To me, it's like she hasn't given us any actual evidence yet.
You'll hear
She hasn't
from
stated
witnesses,
any evidence. It's
both
these
law
we
enforcement
object pretty quick
and lay witnesses
because
who personally
all of this
experienced
is just narrative.
and who personally witnessed the activities, the crimes that were committed. You will hear from law enforcement officers like Kimberly Underwood
There we go.
and Tyrone Dennis, whose main goal wasn't to go out in the streets and lock up people who looked like them. It was actually to touch souls in the streets, to touch young people, and to alert them of the dangers and the drawbacks of becoming a part of and becoming involved in gangs like YSL and Rock Crew. You'll hear about conversations with educators. You'll hear from members and associates of the gang itself. Now, as to how those members and associates will respond or act once they're actually in court and on the stand, that's something that I am truthfully not able to predict to you fully.
Okay, when I heard that, that reminds you of how it made me excited for the trial. And it reminds you of how opening statements and closing arguments always get all the attention because it's what's easiest to watch and what is most like a movie. But the most interesting part and the most crucial part of a trial is obviously the testimony, like she just alluded to. She has a bunch of witnesses she's going to be calling, and she basically just warned the jury. She doesn't even really know how it's going to go. And it could, we could have some situations there. And that is obviously the heart of the case, because right now in her opening statement, she's just stating what she thinks the evidence is going to show. We haven't actually heard that much of it. She's kind of just saying a lot of like different narratives here, and she gets an objection soon over that. But the closing argument is when your case is really supposed to come together, like especially a complex criminal case like that. And that's when she has a little bit less freedom in an opening statement in that she has to argue the evidence as it came in. So she's going to be putting it all together based on witness testimony. So it just kind of underscores how crucial the witness testimony is, because you can write your opening statement all you want, but once the evidence and everything, the testimony starts coming in, that's what really dictates how good or how strong your closing argument can be and what you're actually going to be able to argue here. So let's get back into it. The clip comes soon where she does the burden shifting, where, like I said, my jaw dropped when she started saying this, because this seems like a real rookie move for a trial prosecutor, like not to understand, for her to think that she can say what she says right now.
But the court has given you instructions on determining and judging the credibility of the witnesses.
This is fine.
And I trust that all of you will in fact follow those instructions. The evidence will show that YSL checks
This is fine.
all of the boxes for being a criminal street gang. As I stated earlier, they are 3 or more people associated in fact. Their members commit crimes on behalf of the gang. They commit crimes such as armed robbery, hijacking, motor vehicle theft, theft by receiving, stolen firearms, so many stolen firearms, possession of a machine gun, and narcotics sales.
Yeah,
And last and certainly not least, murder.
Here comes the WTF.
What you will not hear any evidence of is that the defendants were not involved in a criminal street gang.
What the fuck?
You will not hear any evidence that they did not commit crimes on behalf of YSL. And as I stated to you earlier, what I'm saying to you now is
Let me object to that statement,
Yeah.
please, as burden shifting.
Object basis?
Burden
We should
shifting.
know what the basis.
And under Parker
What
versus
was-
the state.
What was really interesting to me, the way they do objections in different courts obviously varies. But when I went to, I cover trials on the West Coast in California, and when I went to New York, the Southern District of New York, to cover Michael Avenatti's, the lawyer's trial for defrauding Stormy Daniels, the adult film actress, the first thing I noticed in the Southern District of New York, at least in Judge Furman's courtroom, was when the attorneys make objections, they don't give a reason for the objection. And I think that's one of the most interesting things to watch for in trials, is the objections, the reason for the objections, why the judge sustains or overrules. And sometimes, like in the California, the LA federal courts that I watch, you'll hear the judge, the objection, the attorney will make an objection and state a reason, and the judge will overrule the objection, and they'll say on that grounds. And they're kind of hinting to the attorney that there could be another federal rule of evidence violation or something that they could be citing to get a sustained objection, but they need to be the one to bring it up. I mean, especially sometimes depending on the judge, like a judge isn't going to give any hints, or like they're not going to make the objection for you. Whereas in the Southern District of New York, it was like just assumed that everybody knows the federal rules of evidence. So when an attorney makes an objection, you shouldn't have to state what the reason is, because if everyone is following the federal rules of evidence, it's just supposed to be like obvious what the objection was. But to me, like coming from the West Coast and seeing it never done that way, like everybody states the reason for the objection, because sometimes the reason stated for the objection like isn't correct, and it leads to objection being overruled. To see a court where they didn't even demand that was really weird. So I've never watched trials in Fulton County, Georgia until now. So it was refreshing and in line with everything I've seen that they state the reasons for the objection. Like the judge just now said, what's the reason for the objection? Although frankly, that burden shifting was like so obvious to me that some judges I've seen would have not waited for an objection. They would have just intervened. But
277.
It's a small courtroom. There's not too many people.
277.
Why don't we take that up then?
39.
I'll note your objection. I'm sustaining the objection. Why don't you rephrase, madam?
Yes,
And it's
Your Honor.
weird for how angry the judge gets with people. I'm surprised he
Ladies
was
and gentlemen, I'm
angry
going to
at
explain to you what
That
I'm
was
going to
like
explain to you at
total-
the appropriate time, ladies and gentlemen, what the burden is in this case. Remember what I told you earlier, that the burden never shifts to the defendants to prove or certain innocence, they're presumed innocent. And it's only until you hear evidence that you decide is sufficient, and I'll instruct you on how you're supposed to do that at a later point in time, okay?
It's a good idea. Let me put the captions on.
The evidence will show that YSL did not adhere and does not adhere to all of the customs of a traditional street gang.
Do I have that on?
And the fact that YSL does not mirror all the customs of a criminal street gang, the evidence will show makes it no less a criminal street gang. The defendants on trial here today have, through their actions, displayed not only their allegiance, their alliance
Should come up
with
here.
one another and with the
It looks
gang
like the
itself.
caption should come up here, I think.
Through their actions, they have displayed an unspoken agreement to participate in that gang through a pattern of illegal activity. And again, the head of this gang is seated in this courtroom too.
This is arguably
paragraph
argument what she's doing.
That point
She's
that I read
he's
was
concluding
so
he's the head of the
earlier.
gang. She's not saying the evidence will show that he's the head of the gang. She's just like, yeah, he's the head of the gang. He's sitting right there.
Because of his age and his cunning.
Sorry, the
Because of
caption's
his
right.
right.
This
and
is
his
argument.
Yeah.
This is not,
What's your objection, Mr. Harvey?
that it's argument.
Okay, Mr. Harvey, hold on.
Let me see
Madam,
if I can
it
get
is
the captions
argument at
on
this
here.
point in time, so I'll sustain the objection, okay?
Yes, Your Honor.
All right.
The evidence will show that these defendants, that the members and associates of YSL, they knew who their leader was, and they knew the repercussions of not obeying their leader. You will hear evidence that when members and associates of YSL got in trouble, got locked up,
See, I feel like a much
The
better
first
opening
person they
statement is saying
call
you will hear
would
evidence
either
that
be
shows
the
this.
defendant
Like, show us
or
what.
one of his family members.
And I'm assuming that comes later
Now,
on.
they didn't call him directly because he knew and they knew that he needed to have distance between himself and the crimes members and associates of YSL were committing on behalf of the gang. So they would reach out to his sister and have his sister reach out to somebody else and eventually get back to King Slime, as they call him. You will hear evidence that members of YSL committed armed robberies. You'll hear evidence that to slime someone is to do them dirty, and that sometimes members of YSL committed crimes against other family members of their fellow gang members. You'll hear evidence that when one of the associates or members of YSL did something to what Jeffrey Williams had perhaps considered a friend, they were threatened with their very life. Tell them to get that stuff back or they will be killed. You'll hear evidence that YSL, they had opposition.
Again,
within
what
the
is
city
that
of
evidence?
Atlanta and Fulton
Because
County.
she's arguably
That there were other gangs
arguing what she thinks
that
the-
were
and showing-
at various
telling
points
us
in
what the evidence
time at odds and even at war with YSL. One of those gangs was known as the IF gang, IF, Inglewood Family. You will hear experts come in here and tell you more about how the Inglewood family bloods in any way made its way down to Fulton County. You will also hear evidence about how one of the members, one of the beloved, of whom YSL considered an opposition group, was gunned down. Donovan Thomas on January the 1st, 2015. January the 10th, my apologies, 2015. gunned down, openly and notoriously. Because the evidence will show that part of the reasons that criminal street gangs operate the way that they do is to establish dominance and to establish control and to establish fear. You're going to hear that this gang stole at least 3 lives from this community over the last 10 years. At least 3 that are referenced in this indictment. You'll find that as a result of this gang's activities, a young woman who had nothing to do with either YSL or any of their opposition was gunned down by people trying to get back at YSL for what they did. You'll hear evidence that after the murder of Donovan Thomas, no less than 50 shootings occurred over the course of the next several months. You'll hear evidence that hundreds of bullets were fired into cars, into homes, and into people as a result of the rift Young's Limelight had with other people in the community. So what are they accused of, and what are you here for today? The judge read the 4-hour-long indictment to you 12 months ago.
I always cringe when the attorneys do this in openings.
He didn't read it to you again today, but he generally gave you what each defendant is being charged with and what the state has the burden of proving beyond a reasonable doubt as it relates to each defendant. But just to broadly touch on those, the crimes that the state will be proving to you over the next several weeks include conspiracy to violate the Racketeer Influence and Corrupt Organizations Act. That is an absolute mouthful. So we'll just say RICO.
RICO.
There's no substantive allegation of RICO violations here. And by that I mean there's a difference. Here the state is alleging that these defendants, they had an agreement, unspoken, but no less an agreement, to obtain property, things of value, cell phones, cars, stolen guns, through a pattern of illegal activity. The evidence will show that it's sort of like if 2 people said, okay, you know what, we're gonna go toilet paper our dean of admissions house.
What? No.
And they sat there thinking and talking about it. And someone
I'm assuming there are
overheard
college
them
students on the
and reported
trying
them
to appeal
to the police.
demographics of
And the police came and said, okay, I'm gonna arrest you all for conspiracy, for planning to go and do this. The evidence will show that it's not enough that they were planning to do it. Somebody has to do at least one thing in order for those 2 people to be found guilty of conspiracy. So say one of you goes and says, let me go get the toilet paper now. Then y'all are in trouble. That's what we have here, and that's what the evidence is going to show. There was an agreement among the members of YSL to obtain property and things of value through a pattern of illegal activity. And it is their actions over the course of the last 10 years. It did not stop, by the way, in 2015. It didn't stop at all. It continued up through and even into 2023, after this case was indicted, as the evidence will show. But their actions are what the state will be looking to you to evaluate and determine. Does this action show that they're agreeing to participate in this organization, this enterprise, through racketeering activity. You'll see evidence, as I stated, of not just drug sales, trap houses, drug houses, whole houses out of which drug sales were conducted, where they held long-arm guns by the door, where they stood ready to act on command if either one of their number called. Who's on trial before you today is Rodalius Ryan, Quamarvious Nichols, Marquavius Huey, Jeffrey Williams,
Young Thug,
Shannon Stillwel, Deamonte Kendrick. And their actions during the dates that are listed in this indictment are what we are asking that you pay close attention to and you evaluate.
Your Honor.
It-
You have an objection?
Yes, sir.
Basis?
For the motion.
Okay, so this is when we don't see the
Um,
screen, but she put something up on the screen that hasn't been disclosed. That's Young Thug's lawyer, Brian Steele, who I like, by the way. He seems awesome. He's got
Ladies and
that.
gentlemen, this is one of our breaks.
Got
I'm
that
going to need to
winter
probably ask you to retire to your headquarters at your deliberation room, and we'll call you back in just a minute, okay? And we'll finish up our business, all right?
Even one objection during an opening statement is to have like it all interrupted.
Remember the court's admonitions, ladies and gentlemen.
What is going on here? This is not good. And this was it too. Like since then, the jury has not been back to hear opening statements. What time did this happen at? This was like an hour and a half ago or something. But they all yelled about this for like 40 minutes or something after this. But it was just crazy to me how to hear the DA, we'll hear it later on here, but to hear the DA be like, oh, well, maybe we could just do a curative instruction.
All right, please be seated. Our jury
20
has
minutes
left
into
us.
your opening statement, we already need a curative instruction? Like, hell.
All right, Mr. Steele, what's your motion, sir?
Good morning again, Your Honor. Your Honor, last week, 2 weeks, 3 weeks ago, you ordered the parties to share all of their displays in
And
opening statement to
really
the others so we don't have to
like-
have these interruptions. I did
Like
that.
every trial
The state shared with me
asked them to do that.
4 attachments. That's all they had. That's what I got. What you just saw on your screen, if you don't remember, I'll ask the state to put it up and I asked for it to be marked as exhibit, is what you already excluded. It states that Mr. Ryan was convicted of murder and I represent the co-defendant who's not on trial on the appeal. How did that not get sent to me so I could bring it to this honorable court's attention? 1. And 2, how do we just violate court orders? So yes, I have a serious motion for a mistrial because it's intentional misconduct. That's my motion.
Yeah, and I would say like a lot of the times when you hear mistrial motions, I mean, some are more serious, less serious than others. I mean, the chance that there's going to be a mistrial 20 minutes into the opening statement, not likely. But you can tell that this is a big issue, what just happened, and to have that kind of screw up like that, to not only have her putting slides up there that haven't been disclosed, which frankly is kind of common, but the big problem here was they, as Steele said, one of the slides had information about a criminal background that Steele claims was precluded in a pretrial motion here. So you can kind of hear from the tone of his voice that this is a little more serious than just going through the motions to preserve the record kind of thing. So let's hear what the judge said.
All right.
And I'd like the screenshot to be captured for Ms. Weaver to put in the record.
I'll admit it.
Yeah, because right now we have not seen what she saw.
Anyway,
we didn't see what she
all
was
right,
putting
so
in.
that'll be court 1 for purposes of trial. So, Ms. Love, what's your response to Mr. Steele's assertion about Mr. Ryan?
As it relates to Mr. Ryan and the exhibits that the state intended to play into display for the jury, I sent to Mr. Steele and everyone else the pictures and the photographs that I expected to use as it relates to the slide to which Mr. Steele is now referring regarding his representation on appeal. I'm not certain if the objection goes to the fact that there was the conviction, because that's part of the indictment and that's part of the evidence that the state expects will show, or if it's as to his objection about the fact that he represents Mr. Ryan or Mr. Blaylock on appeal.
Don't represent Mr. Ryan.
Mr. Blaylock, then.
Excuse me. I have never said this ever. That's it.
So what's your objection based upon, Mr. Steele?
Objection based upon, I argued this before the Honorable Court. You argued the prosecution that before they ever mentioned my name, you granted this motion.
That I did.
You brought him up to this Honorable Court, outside the presence of everybody. We're an open statement. I am lied to. I am saying that. I am lied to. Or if anyone else got that exhibit, I did not get that exhibit. And I'm seeing everyone say shaking no. And now it goes against the court's word. We are bound, duty bound, to follow Honorable Court's order.
I'm going to join in the objection on behalf of Mr. Steele.
Let me see the.
I can put it back up,
Yes,
Judge.
ma'am.
And Your Honor, while I am putting that back up, I will state in my place that initially when there was the objection from Mr. Steele, I didn't have a clue what it was about because I didn't mention his name and didn't intend to mention his name. As I looked at the screen, I saw that part of his name was on the screen for the most part.
But I mentioned that.
Okay, yeah, that's really bad. I think they put the here in a minute here we'll see the slide that they see, but just having Brian Steele, who's Young Thug's lawyer, his name was up there on the screen, and I don't know, the idea that jurors like recognized his name or associated that, I mean, I kind of doubt it. It's pretty early on, but you just don't know. So and then to have the DA saying, oh, I didn't realize, and then as it was up on the screen, she realized, it was like, wow, that's kind of sloppy. But we'll see how it goes here.
Ruled upon that last week. I did. That we were not. I would take it as it came in this case, and if the evidence got to that point, then I would deal with it accordingly.
Yes, Your Honor.
So,
And Your Honor, as to Mr. Steele's motion, as I'm pulling this up, the state would vehemently object to a mistrial and ask for a curative instruction and a reminder to the court, to the jury, that nothing that the lawyers say is evidence in this case. This is not at all the type of thing that rises to the level of mandating a mistrial. Certainly not. It just isn't. I have
all right.
the slide.
Pull up now.
I have it now. I'm
Court
about to
adds
share the
court
screen.
one for purposes of the motion for mistrial. All right.
Okay, yeah, here's the. Let me see if I can.
Okay, on slide 11 of 65, that I see where you have.
Yeah,
that,
represented by Brian Stee.
at the bottom.
Represented by Brian Stee.
So, we can leave that for the time being. Leave it for the time being because it is what was it was up. I'm going to deny the motion for mistrial, Mr. Steele, but I will go ahead and give a curative instruction to our jurors at this point in time. So,
Your Honor, I'm supposed to ask for a re-occurrence report from my mistrial before the next process goes on. I'd like you to do me a courtesy, if you would, and allow me to do that now and preserve the motion for mistrial.
You've made your motion for mistrial, and the basis, and I'm going to mark the whole state's presentation as court one for the purpose of your motion, and it will go in as stated.
And I have two other issues I'd like the court to just take up. One is just remember, I know you ruled on it, but the state said earlier today that Mr. Williams is contacting through parties that they don't know to pay for other people's lawyers. So I think that couples with that exhibit. And number two, I'd like the court to now order prosecution to give me and anyone else who wants to see it. I need to see respectfully what you ordered last week, all of the displays of the state of Georgia that they have not given to us. So
What do you mean by what displays are you talking about, Mr. Steele?
I never saw that. I never saw the wolf. I never saw the indictment. You ordered I gave all my displays. I gave everything to the state. I got from the state.
Are you talking about using for opening statements, sir?
Of course.
Okay.
Should have been done.
All right.
I'm disappointed that during her opening we weren't seeing the screen that was being shown to the jurors in the courtroom, because you guys heard Steele just reference the photo of the wolf. I'm like, oh God, they had some photos of like wolves when she was talking about the wolf pack, but it reminds me of the Harvey Weinstein closing argument in LA. The DA compared Weinstein to a wolf, like a predator. And she had like this Google clip art of a wolf that, sure enough, if you just went to Google and Googled like wolf clip art, it was like the first thing that came up or something. So I'm now curious what kind of wolf the Fulton County DA used in their PowerPoint, but perhaps we'll never know unless somebody within the courtroom got it on camera or something. But
All right, Ms. Love.
Yeah.
Wait.
Thank you, Your Honor. Two matters, Your Honor. One, the first thing that Mr. Steele has requested of the court regarding the representation that the state made about other YSL members contacting Jeffrey Williams for representation is absolutely and has always been a part of what the state expects will show at trial.
I'm going to deny that portion, but to Mr. Steele's point, I'd already made that issue in terms of his particular involvement, and anything you need to let me know prior to that, and I need to rule upon it, and also subject to foundation, just like this. So I assume that what you told our jurors is what you expect the evidence to show. Yes.
Yes,
All right,
definitely.
so I'm gonna overrule that part of his objection. What about the last thing you mentioned?
And Your Honor, as to the court's directive that we turn over anything or any exhibits or photographs, that was my understanding of the court's directive, that we expect to show an opening statement. As a matter of course, I can again reiterate the fact that it was an inadvertent omission to leave Mr. Steele, at least part of his name on here.
I got that, but he's talking about, is there anything else you're going to use in opening you haven't shown to the defense counsel?
I don't mind sharing.
Well, I said that. I told you to do that a week ago.
Your Honor,
Because here's what I told you was going to happen. I've got a jury that's out right now that's being interrupted. And Mr. Williams, you should have made your motion or should have told me about that an hour ago or when you found out about it.
okay, I can kind of see his point there, where Williams, realized early on that he didn't have the slides. Maybe he could have brought it up sooner. But just the way the judge is like so seethingly pissed off about it, it's like, what good is that doing? Like, how is he like solving things and like moving things forward by just ripping into that lawyer for not telling him about this sooner? It just seems like it just makes everything so much stressful in an inherently stressful process when you have some guy who just rips into you like that.
Not hijack me at the bench about that. You did what you had to do, but I'm not happy about that. I'm not happy about any of this.
Wah, wah.
Because this is stuff we could take care of before our jury comes in. And that makes you all, lessen your ability as advocates and lessen our ability for this jury to go ahead and get this case seamlessly. This is what I told you all was going to happen. So,
and that right there,
have you given them everything you're going to?
This is what I told you all was going to happen. It's like, okay, so the judge foresaw problems and knew this was going to happen. It's like, could the judge have done something to like make it so this wouldn't happen? I mean, it's always easier said than done, but there's that judge that I watched do the Kobe Bryant crash photos trial where, I mean, he would require all this stuff to be disclosed, but then he would actually have like a status conference to make sure it had been disclosed. And granted, I think they did that because we did have the Thanksgiving holiday. So it's not like they were going to have a status conference on Friday. And when did they have the last motion hearing? Was like a couple days before Thanksgiving was, but I mean, they went until like 9:30 at night or something. It's like, are you people like functioning adults who like work in the workplace? Like, come on, but it's just, especially with 6 defendants and 6 defense attorneys like that, there's all these different personalities and people to juggle.
Show them during opening statement.
Your Honor, I haven't given them all of the word slides. I did give to them what Mr. Williams objected to. I had given that to them previously. I will give them or share with them the things that have been added as of this evening. And
can you do that over the next 5 minutes?
I sure can.
Deputy Ingram, can you find out if our jurors are ready? Are they ready? Are they still using the restroom?
I'll send that to them right now as we're waiting.
Your Honor, Jay Apt on behalf of Mr. Kendrick, can we have 5 or 10 minutes to review whatever Ms. Love is going to send us?
You can take a comfort break, and I'll come back at 10 of 12. And like I said, whatever we don't finish before 12:15, we'll pick up after lunch. Okay?
Thank you, Your Honor.
Okay, so yeah, and then they just
who's talking?
That's Sharp.
Yes, Mr. Sharp.
On behalf of Mr. Stillwel. We've been operating pretrial with the Harvey rule. I want to make sure that the record is clear that we join Mr. Steele in his motion for mistrial. And if Your Honor...
I'll apply the Harvey rule unless you tell me otherwise. Okay?
And that will apply throughout trial?
Yes.
Okay, thank you.
Unless you tell me otherwise. Okay? All right.
Thank you.
All right, we're going to be in recess about 10 minutes, all right?
Your Honor, what I'm going to do before stating is I'm going to actually do a search for the first 4 letters of Mr. Steele's name to make sure that I didn't need anything else in there. So before I do that, I'm going to send that. I'll make that search.
all right. So they end up being gone a lot longer than 10 minutes. I mean, what is it, right? 101. Well, not all that much longer, maybe like 15. They bring back the jury in. And just send them away. So I think they're going to be back here in like 25 minutes or so, but we'll see. What a cluster.
All right, have we concluded our sharing exercise? I told you all to go ahead and talk with each other through when we broke.
I did share, Your Honor.
All right.
If I may, Your Honor.
Yes, ma'am.
Regarding the court's earlier concern brought to the court's attention by Mr. Williams, Ms. Hilton shared with me what was said on the bench. But as it relates to Rodalius Ryan's post after the murder of Shamel Drinks, that was provided from day one in discovery, Your Honor. And it is not a crime that he is alleged to have committed. We may have put that on a list, out of including things, but Your Honor, that is not an intrinsic act in the sense of it being a crime or criminal act. And it is what the evidence is going to show happened. What I have in the PowerPoint I can show to the court if you like. I sent that to defense counsel prior to today. I think I sent it Friday before 5. But what I have said is that on the day that Shamel Drinks was I'm sorry, Jamari Holmes, my apologies to the court and to the family members here. What I said was that on the date that Mr. Holmes was gunned down, 12 hours after that murder, Mr. Ryan posted on his Instagram account, I bet YSL makes the news. And what I endeavored to say to the jury, that the evidence will show is just that they were advertising and representing and boasting on behalf of the gang itself immediately after the murder occurred. And these are elements that the court, I believe, will hear from detectives and evidence. These are the things that the court has said jurors and the courts should look to in determining whether something is done in furtherance of a gang. And so I would ask the court, I didn't take it out as the court instructed. I would ask that the court allow you to make reference to it. And thank you, Your Honor, for your time.
All right, Mr. Williams. Oh, sit down, Mr. App. You can just wait a minute. All right, Mr. Williams. What's your response, madam?
That the court already ruled on that, saying that you would bring it up as it comes forth. You stated that they couldn't use it in the opening, and I would just ask that the court use their instruction and make the state follow the instruction that the court already gave.
Okay, but it may not be what I think that Ms. Love is saying, Mr. Williams, is that the evidence may not necessarily be intrinsic. It might be for another purpose. It's what they expect the evidence to show. So, but here's the issue that kind of I'm disappointed as the court. We've had months and months and months. We could have taken this up before. I could have made it very clear. I don't need to take it up right on the eve of our jury sitting in the box. That's what I'm kind of more annoyed with than anything else. If you had clarity or wanted to seek clarity on that, I'm more than happy to rule on it, but I needed to go ahead and have some ability to do so. So I don't think it's intrinsic. It may be for other purposes, and I'll let the state reference that if they have a good faith basis to, that if they believe that's what the evidence will show. Okay?
They put it in their motion as—
Say again, madam, I'm sorry.
They put it in their motion as intrinsic evidence, though. So they shouldn't have put it in their motion if they were going to—
Yes, ma'am, I would probably agree with you, but
So
did I ever rule on that issue?
You said that you would do it later as it came
Okay,
up.
well, here's the thing. Later is now. I got a jury in the box, so you could have asked me that an hour. I mean, we had time this morning. I could have gone through that this morning and made clarity on it for both sides.
Well, they didn't, man. So,
But do you have any other basis for the ruling? I mean, for my ruling, madam, any other argument?
No, just I wish that the court would just follow their own instruction.
Well, I'll follow my instructions when you all bring to my attention what you need to in a timely manner, okay? And give me the full breadth of, so I can rule upon it accordingly. That's what I'd like you all to do.
Well, they also have slide 45. They have my client's name on there as gunning down a 23-year-old, Shymel Drinks, and my client has nothing to do with that.
That was another area I'm
But I didn't get that
Ms.
slide
Love says
presentation
Ms.
earlier.
Love says she is going to remedy that and exclude it.
Thank you, Your Honor.
Okay, all right. Now, Mr. App, what is it you want to tell me?
I am so sorry, Your Honor. But thank you for allowing me to speak. I do have an objection, Judge. So, Ms.
What's your
Love
objection specifically, sir?
attempted to email us during the break the PowerPoint slides that she is using in opening. I could not open the attachment. I brought that to the attention of her co-counsels and staff, and Mr. Matthews was able to open it, and I looked over his shoulder and was able to see some of it. There are at least a dozen more slides that were never turned over to us, even though the court instructed us to share with the state and for the state to share with us prior to opening any exhibits for opening argument. And so, I mean, these are all new to us, and I would just ask that the ones that she did not share, she shared 4, that the ones that she did not share be excluded. I'm objecting because the court ordered for us to share these. She did not. Clearly, she did it intentionally. There's also apparently factual errors in them. I would ask that any slides that haven't already been shown to the jury and that she did not disclose be excluded from her opening argument.
Yes, ma'am, and then I'll go on to the next person.
Thank you, Judge.
Yes.
Your Honor, I did not send only 4 slides or attachments. I sent to counsel for the defendants the photographs
Unbelievable that they're doing
evidence
this in
that
the
I
middle of
intended to put into the opening PowerPoint. As far as the state's theory of the case and theme of the case and the words that I wrote, those are things that were being developed, ongoing, and I did not understand the court's directive to me that we needed to turn over the words we would be speaking. As far as these photographs go, Judge, I said to them, if they can, actually, I sent them to them. So there are some, I have only about.
Your Honor, they're done over.
Hold on, wait, let her finish, and then I'll let you respond, Mr. Abt.
So all of these slides that involve Christian Ebinger, I sent to them. And other than the slides involving Christian Ebinger, there is a slide of the vehicle that Donovan Thomas drove on the day he was gunned down. It's the back of the vehicle with the placards of showing the bullet defects. That will be shown. There's no one that has made any objection to that evidence being introduced at trial. Nothing that I have put in the PowerPoint includes anything that has been objected to as being admissible at trial. And I believe that, I'm not certain if Mr. Abt thinks that we only served 4. I don't know if he had trouble opening it up, but we served, I think all of them, if not the great majority of them, because I don't have that many. I don't even have 20 photographs in this PowerPoint. So everything, and I can show the court, I would share it if I did not with the court as well. But these photographs, I have a picture of Donovan Thomas in life. I have a picture of the barbershop where he was gunned down. I have a picture of the back of Donovan Thomas's Tahoe. I have a picture of Donovan Thomas's headshot. At the time of the autopsy, no cutting, no nothing, just his face with the number. I have a picture of, as I stated earlier, Your Honor, the truck with the defects noted, and then I have pictures of Christian Ebinger, all of which were provided, and that's the extent of it. The majority of the slides have my words, my work product on them.
All right, Mr. Abt, before I go ahead and respond.
Your Honor, no one's suggesting that she had to turn over the text of her opening argument, but if she's going to show a PowerPoint to the jury, that is what the court instructed us to share. We're visual exhibits, and that's what she's doing. She's placing it up on a screen for the jury to see. And whether that's her own words as part of her opening as a PowerPoint, or it's just demonstrative, she could have shared it, and she didn't. And she did it. And she's suggesting now to the court as a work in progress that she hasn't worked on her opening statement until this past weekend. I don't believe that. I think if that's the case, then she's just lying to the court. But if that's not, if it's not,
that's when I kind of winced and tweeted that, courtroom conditions continue to devolve because the attorneys are just pissed. But, usually in court, they'll try to be a little more respectful or tactful than just outright calling each other liars. But that guy's just like, I'll call it like I see it.
And she didn't mean to mislead the court just now, then she could have and should have shared those PowerPoints. As to the photographs, those also could have been shared with prior to opening. If there's no one's suggesting they're not admissible at trial. If they're admissible, she can admit them at trial. But to show them to the jury now is part of her opening that violates this court's order that we were supposed to share our exhibits for opening prior to trial, which she did not do. So I think they should be excluded from the opening. And if she wants to introduce them later as evidence during the course of the case, then so be it. But I think there is good grounds for this court to, and Your Honor got upset because these issues could have been handled. They didn't have to wait until now. This is wasting time while the jury's waiting. Your Honor's right. And it's not our fault. It's her fault for not doing what the court instructed. And as a result, the appropriate and reasonable remedy is to prevent her from sharing any of these slides with the jury that she did not share with defense counsel prior to today, whether evidence or whether their text is part of her opening.
All right, Mr. Matthews.
Yes, Your Honor. Good morning to the honorable court. I'd like to direct the state's attention to slide 15. In slide 15, the third bullet point, it references October 1st, 2020, in terms of that quote from a text message. In the indictment, Your Honor, if you look at Overt Act 102, that's where that particular quote comes from, Overt Act 102. In Overt Act 102, the date of that alleged text message was March 12th, 2020, not October 1st, 2020, as in the PowerPoint presentation. So number one. Number two, the quote in the indictment is different from the quote in the PowerPoint. So that's two errors in slide 15 pertaining to Marquavious Huey. And then you go to slide 16. Slide 16 is an overt act that is alleged in the indictment as Overt Act 123. In the state's opening presentation, the date they have is October 1, 2020, but in the indictment, that particular overt act is November 16, 2020. So that's a third error in the state's opening slide presentation. So those need to be corrected to mirror the indictment so that it's not misleading the jury and in fact giving wrong information to the jury judge. So I would ask that the state correct that, remove it, or correct it.
All right, anybody else? Yes, Mr. Short.
Your Honor, on behalf of Mr. Stillwel.
Speak up, please.
On behalf of Mr. Stillwel, slide number 47, it suggests that Mr. Stillwel is still committing crimes on behalf of the gang, even after being indicted on these charges. We began to discuss intrinsic acts and other unindicted allegations last week, but we did not get through it. And my understanding was that anything that you had not ruled upon, we were not supposed to reference or discuss in opening statements. So those are clear references to unindicted charges that we did not get a ruling on its admissibility yet. And I would ask that that just be taken out of the presentation and no mention be made of those.
Anybody else? Yes, Mr. Steele.
Thank you, sir. If you would look at also number, I'm looking at now 48, 49, 53, 54, 55. That's your prerogative. That's within your zone. That's law.
Would the court allow Mr. Steele to repeat those slide numbers? Because what I think that he's referring to is something that I placed in here that the court said during its preliminary instructions to the jury. And it was regarding the court, as a matter of fact, it was the last thing that the court said. And all that I did was put on the slide, judge's law.
In terms of what slides you talking about, Mr. Steele again?
I have 48, 49, 53, 54, 55.
So 49, 48 through 55?
Excluding, so 48, 49, but then skipping to 53, 54, and 55.
48 and 49. Your Honor, may I share via Zoom the slides that Mr. Steele?
I would, yes, please.
Thank you. And you said, Mr. Steele, you said 45?
Just share the presentation, please.
Yes, Your Honor.
Yeah, somebody asked. See somebody asking why the feds didn't pick this up. And my first reaction when I was like looking into this case was, you would never see a case like this.
Your Honor, I'm showing on the screen slide 48, which is the last thing that the court.
Take notes.
Yes, Your Honor.
All right.
And
49.
But you would never see a case like this from the LADA's office.
that was directly from what the court just stated.
All right. 50.
And 50,
It's not 50, sir, 53.
53. Let's get down to 53. And 53 is what I expect the evidence is going to show. So I'm going to, in speaking to the jurors regarding the witnesses and the instructions that the court has given them, I'm going to say to them, some of them, as I've already alluded to, some of them may not be wanting to speak. Some of them, you're going to see evidence that some of them are afraid, some of them are embarrassed, some of them are intimidated, some of them don't remember, some of them don't want to remember. That's simply what the evidence will show. And Your Honor, what I'm asking that the jury does in listening to and considering the testimony of any such witnesses is, as the court has already instructed, which is just to use your common sense, because you alone decide who you believe. We're asking you to listen carefully, take notes, and pay attention. So there's nothing in that slide 53 that is in any way infringing on or entering into a lane that does not belong to the state. We are entitled and allowed to show and to state to the jury what evidence will show. The way that I have decided to represent it in writing makes it no less so.
Yeah, but it borders on argument at this point in time.
Yeah.
So I can change it because I do expect that the evidence will show that some of the witnesses are afraid, some of the witnesses are there. So I can take out.
Well, that's different. You might want to just redo it.
I can do that.
Any further objections, folks?
Yes, Your Honor, I went over to the state's table, Carson Matthews and Mr. Huey, went over to the state's table and brought to their attention an error in slide 42, and I think it's incorrect.
All right.
Are you sick of having issues with your webinars,
wasting
tons of time on troubleshooting with
Yeah.
attendees? If so,
hit the ad.
Folks, this is exactly why I told you. I wanted you to, and let me go ahead and just say this, Ms. Love. I told you to give them your PowerPoint presentation. This is why you give it to them, so that they can get errors and they can also figure out if there's something they object to. So this is what's caused this delay. Because at this point, like I told you, there's no secrets in the trial of this case. You all have gone through quite a long process. But this just highlights the concerns the court had in terms of just breaking up the presentation for our jurors. So what I'm going to do, ladies and gentlemen, I'm going to go ahead and call our jurors out. I'm going to go ahead and release them for lunch. I'm going to tell them they're going to be at lunch until 1:30. During the lunch hour, Ms. Love, I want you to play or the slides that you have that otherwise have not been shown. You need to show them to the defense counsel and make sure they're correct. In the absence of them being corrected, I'm going to exclude your presentation.
They have the presentation.
But it needs to be correct. I don't want, if I get another objection about an error, I'm going to exclude it for the purposes of the opening statement because you didn't follow my instructions. This is why I told everyone. And the defendants needed to give you their opening statements and the things they wish to use during their openings as well, because we're having interruptions and delay, and that's what I wanted to avoid for jurors. That was the reasons I told you all to do that. So,
Your Honor, as far as any typographical errors.
I'm not worried about that. But I'm not worried about that. But the errors that Mr. Apt, Mr. Matthews, and Mr. Shaw have made our error and Ms. D. Williams need to be corrected, okay?
Yes, Your Honor, I will, of course, do it for the record.
And, but everyone else needs to see it so they can be comfortable and make sure that you represented something that what you expect the evidence to show to be correct, okay?
Thank you, Judge, will do. And, Your Honor, I also wanted to point out to the court that even if I misspoke, the court has already instructed the jury and will continue to instruct them that nothing I say is evidence, and if I misspeak or miswrite,
But that's not the point.
Yeah.
I'm gonna tell them that, but and I told them that already. But that's not the point. The point is so that we can have a smooth and orderly presentation of evidence. Okay. So, all right. Definitely. Sergeant Ingram, can we go ahead and call for our jurors, please?
The prosecutor was definitely right that, you know, what she says is not evidence.
You can go ahead and take up that during the recess. Okay.
Yes, sir. Thank you.
All right. Yes.
Like the whole idea is, you know, you as a prosecutor or a defense attorney, you want the jury to be looking to you as the one who always has the answers, who's, you know, always, you know, telling the truth, who's, you know, in charge of the courtroom. So if she's saying something that is not true, if there's like a date error or a factual error and jurors are noticing it, you know, it's not good for her for sure. But they're all standing for the jury to come in, and obviously the cameras are forbidden from showing the jurors. So, and I haven't read much on jury selection about who's actually on this, but just based on some of what the DA was saying in her opening statement, like the reference she made to, you know, if you were going to like if you had a conspiracy to TP your college dean's house or something, I'm like, okay, there must be some college kids on this jury, just the way she's kind of trying to appeal to him there. But there's 18 of them total, 12 seated and then 6 alternates. I saw somebody ask, you know, why the feds didn't go after this, and obviously the conduct is alleged just in Georgia, but if the feds wanted to go after,
Okay, ladies and gentlemen, please be seated.
Hear what he says to the jury.
All right, members of the jury, we apologize profusely for the delay, but I got some good news. I'm gonna send you lunch. How about that? The bad news is I'm not paying for it. So hopefully you all brought something or have made suitable plans consistent with the court's earlier suggestions to you. So what I'll do is at this point in time it's about 12:20, almost 12:25. I'm going to recess you until 1:45 to allow you to take comfort and taking a big long stretch and get yourself something to eat. I would advise you from doing this a while, don't eat too much carbohydrate laden food because you will fall asleep, and then I'll be looking at you and have to embarrass you. I want to do that. So I just ask you that I'll get a consideration from somebody who's been doing this a while, all right? But remember my admonitions I told you. Remember when you go out, if you should decide to go out to eat lunch, remember you've got a time deadline you need to get back for, because we're going to try and call everybody out promptly around 1:45 or thereabouts and go ahead and get started. Leave your notepads in your basket if you decide to go out there, and remember all the admonitions that I've given you thus far, they apply to you and continue to apply to you. All right, so unless you have any other inquiry of me, ladies and gentlemen, I'm going to bid you a good lunch, and we'll see you back at 1:45, okay? All right. All eyes for a jury.
All right, so they should be coming back here soon, I think. Like any minute.
All right, ladies and gentlemen, please be seated. Our jury has left us. All right, so ladies and gentlemen, consistent with my earlier directions, go ahead and take a look at that, make those corrections, and I'll see everybody back for 1:45, and we'll go ahead and continue with opening statements at that point in time, okay? All right, we're in recess.
All right, so that was the morning in the Young Thug RICO trial. You can tell you did not miss much at all. We are still waiting for them to get back on. It seems it should be any minute now. But yeah, what a cluster! And there are six defense attorneys total. So along with the prosecutor's opening statement, which I don't even think we're like a quarter of the way through, we have six other opening statements, believe it or not, from the defense. So this is, I think, definitely going into Tuesday. I think it was going to go into Tuesday, even if they'd started on time. They were supposed to start at 9 a.m. Today, but they didn't end up starting till like 10:30 or something, because a juror was late. And then we had this big interruption. So I do think we'll get through the prosecution's opening statement this afternoon and maybe one defense opening. But then tomorrow, Tuesday, we're going to be having like marathon defense openings. And I'm not sure how long each is going to be. I did hear in the motions hearing last week that the judge was warning the attorneys not to make them too long, but it doesn't sound like there's any actual time restrictions on them. So I would definitely expect defense openings to go all through Tuesday. And I suppose there's a possibility, possibly it goes into Wednesday, but I think definitely by Wednesday we're going to be hearing the first witnesses, which we have not heard who that could be. So yeah, it's quite a cluster as we went over. I saw somebody ask earlier why the feds didn't take the case, and of course, because it's charged in the state of Georgia, Fulton County, they're alleging only acts within the state of Georgia. But the way this stuff works, if the feds really wanted to go after Young Thug and make this their case, they can easily find federal jurisdiction, like interstate stuff that they can go after if they want to. It's just, if they let the Fed, or if they let Georgia have this case, I don't know exactly why, but they could have gone after this case if they really wanted to. But one thing that just struck me, just thinking about Fulton County going after this case, just like they've gone after Trump, because I mean, this RICO charge, that's been covered pretty well. This is the same type of conspiracy that's being alleged against Donald Trump in the Georgia election case that was brought. The conspiracy cases are a little less cut and dry than like a first degree assault case. It's the same kind of, trying to prove that all these acts were part of a larger RICO conspiracy that you had. I actually covered a RICO case. It was a federal RICO case against the Mongols motorcycle gang back in 2018, and it went to trial in Santa Ana federal court here in California. And I watched, all of it. It was a great trial, but it's so interesting because you hear all about all these different criminal acts, and they're the overt acts that are part of the conspiracy. So at least in the Mongols case, the jurors had to find a certain number of overt acts true to be able to prove the RICO conspiracy. So they ended up finding some of the acts true and others not true. And it was ultimately enough to find the RICO conspiracy true. But it was interesting to see which acts they found true and which they didn't. And at least the federal prosecutors in the Mongols case brought up a bunch of other acts that actually weren't charged as overt acts. Like we just heard about them, like different murders that the Mongols were involved in, like big shootouts at casinos. We were all hearing about that. So I think this afternoon, when the DA gets back to her opening statement, we're going to be hearing more specifics about that. Like, what specific overt acts are we talking about here? Because we've kind of just heard a lot of argument from her this morning. And I will say, so far, it's been a terrible opening statement. And I have to agree with a tweet that I see here. I'm going to share my screen here. This is grotesque. Start by comparing a young black man to wild animals, then leap to slanted logical fallacies, followed by clearly improper legal arguments. Good Lord, what a sleazy opening statement. Yeah, I would agree with that assessment of it there. I mean, it was pretty cringe from the very beginning, it's like, ugh. But what else? I love your guys' comments on here. I mean, some of it is a little, the trolls and stuff, but for the most part, it's just people, listening to the trial and sharing thoughts on it. And Let's see if I got any. It's a little dangerous to be doing it, but yeah, I like this. Oh, this is awful. So bad. Cute blazer though. Express snapped with that collection. Yeah. And that's the thing. Women in court. Men can just throw on a suit, but women, it's a little. They got dressing for success in the courtroom can be. It's not as easy, and men are always paying it, or people are always paying attention to that. Though you'll always see like descriptions of like what a woman attorney was wearing, and you don't really hear that from male attorneys very much. But looks like we're all still just waiting on him here. But if anybody has any questions or anything, let me know. Let me see here. Oh, the actual indictment. So many people have pleaded guilty that the actual indictment has all these names on it that are no longer involved. But gosh, the idea of this shit show of a trial going on for 6 to 9 months when like this is already what's happening to it is no way, man. But somebody was asking me if I thought Young Thug's lawyer is good, and I've never seen him in action, but I do like his let me pull up his handshake that I saw last night. This was in the motions hearing that I made a gif out of, but I think he's definitely like the best lawyer that Young Thug could have gotten for this, because he's Atlanta based. He knows the courts. He does cases like this. He's got that cool it factor to him and everything. So yeah, I definitely think Young Thug has like the best lawyer for the job, and seems to be into it. Oh, I was gonna pull up that indictment. It's like an 88-page indictment. It was filed back in May 2022. So Young Thug's been in jail this entire time. Like, I think people know that Gunna took a plea deal and got out, but Young Thug is obviously not taking a plea deal here. But yeah, it goes through all the overt acts, which, like I said, I expect we'll be hearing more about that from the prosecutor's opening statement here. I'm trying to bring up the law and crime feed here. Make sure we've got it going on here. I just got an invite. I'm going to go on Scripps News tonight to talk about it. Okay. Scripps News is like a streaming service, but they want me on for like a 15-minute discussion about the trial. So hopefully they get back to the actual trial, so I'll have something to talk about. But I'll just be talking about like what a cluster the whole was. But I was able to get my my iMac. It was actually mentioned in that Washington Post profile that I have an old iMac that the monitor is always zapping out on, but I was actually able to get that fixed now. It doesn't crap out on me anymore. I had to empty the trash. It was like tens of thousands of items in the trash, but it got rid of it all. And now I've got the double screen action. So I've got the law and crime feed up on the iMac, and I got my MacBook Pro here going. I haven't heard an actual, as somebody says, what's the estimated amount of days for this trial? I have not heard a specific amount of days, but I've heard like 6 to 9 months to maybe a year for the trial. So that's crazy. That's just ridiculous. But I don't know if ridiculous is the right word, because that'd probably be the same for other jurisdictions because it's such a big case. You've got 6 defendants. I mean, just all the prosecution evidence could take a few months, and then all those defense witnesses are going to have a chance to, or all those defendants are going to have a chance on their own witnesses. Whether they do or not remains to be seen. But let me pull up yeah, here we go. So it's 6 defendants total with Young Thug who are on trial. Here, let me and I do recommend, like, the Atlanta Journal-Constitution has a reporter who's in the courtroom, and he's been following all the all the pretrial stuff and everything. And they've got, you know, photos and stuff actually on the ground, because the Law and Crime Network stream is great, but you know, there's so much stuff that happens that the local reporters get that I couldn't get just sitting at home all these miles away. And I always think we should throw some support to the reporters who are actually like there doing the trial. Here, let me pull up the AJC reporter who's covering it. I'll link to his Twitter in the comments. You guys can give him a follow. He's not like live tweeting the whole thing, because you know he's busy. He's got to write stories for his editors and get all that stuff out. But he's got some pretty good coverage. Like I follow his coverage, and he had a story actually about the guide dog, or the support dog for the judge, because the judge has PTSD. It's like, oh really? You wouldn't imagine by the way he yells at people. But the Atlanta Journal-Constitution reporter did a good story on the dog called Jack. It is paywalled, but still, give him some love on Twitter if you can. Gosh, I'm trying to find his. It's like, what's his name? Javier. Opening statements underway after more delays. Yeah, it looks like they've got a couple people on the Atlanta Journal-Constitution. There's a couple reporters on it. Oh yeah, here Joseph is his name. Joseph Pop. Here, I'll link him in here. You guys give him a follow. Yeah, no, I agree. And the way jurors get treated is freaking BS. Like, I'm still stuck on the lunch situation. Jurors have to put their lives on hold to look at autopsy photos and listen to dry expert testimony. The least we could do is buy them lunch. Exactly. And I mean, and the judge is just trying to make it a little lighter for him by kind of joking around about it. But, oh, yeah, it's real funny that you won't buy us lunch, dude. It's like, come on. I mean, they've got to be there for 6 to 9 months. And, you know, depending on who it is, like, I mean, I think we all kind of take it for granted. Like, the people who can just afford to just go buy lunch every day, you know, it's like some people can't afford that. That stuff adds up, you know, and especially if you're at a courthouse around an area that you don't know, like having to go to all these different restaurants and stuff. It's like, dude, this is a huge burden for some people. Like, but that's one thing I always appreciate about some of the judges that I watch trials with here in Orange County. Like, there's a judge, federal judge, Cormac Carney, who actually was the judge who presided over Cardi B's trial. That's kind of his claim to fame. When Cardi B was sued over the album art by the guy who claimed that she improperly used a piece of his tattoo on the cover to her Gangster Bitch Music, Volume 1. Judge Cormac Carney was the judge on that. And he's like hyper aware of the jury's time. Like, he would not be allowing like a big break like this or any kind of sidebars. Like, he would make the attorneys, like, make sure the attorneys get all this stuff done ahead of time. And the way he is with jurors too, like during jury selection, the Law 360 reporter and I, when we were watching jury selection for the Cardi B trial, we started cracking up in the back row because Judge Carney's just like such a nerd to the jurors too. Like, a woman's walking up to do the voir dire questions on the stand, and Carney's just like, well, ma'am, how about we have this night? You're such a nice, fine citizen. How about you come up here and have a seat and participate in the civic process? He's just like such a nerd. But it's, I mean, he respects the fact that these are just like random people that we pulled off the street, like forced them to come into court. And we need to be putting on like a good show for them. You know, the attorneys who make court their life, like, they should not be the priority. We need to prioritize the lives of these jurors that are being completely interrupted. do you get paid for doing jury duty in the U.S.? Yes, generally there is some kind of payment. It's really small, though. I'm not sure what the actual juror payments are in Fulton County, Georgia, but it's like, I mean, in federal court, it's not that much. I mean, it's like $50 a day, maybe, if that. I'm not sure what it would be in Fulton County, but we could probably look it up. It's certainly not, it doesn't make up for the salaries that they're probably missing at their jobs. Like if some of them don't have jobs that cover all their jury duty days or whatever. So it's definitely a burden for these people for sure. Yeah, in the UK you get a lunch allowance. That'd be nice. I think some different courts allow it, like especially when the jurors start deliberating, you'll see them being brought in lunch in different courts, but it just kind of depends on the court and what exactly is going on. But yeah, a lot of shenanigans and just like a lot of disorganization, you know. They just like anytime you have like 6 defendants, you're going to have, you know, kind of a lot to sort through. But then, you know, the way the judge is yelling at everybody, but they just didn't do, you know, get all this stuff hammered out ahead of time. And the prosecutor was saying something about, you know, just working on her opening or over the weekend, so not disclosing the stuff ahead of time like that she should have. Let me see if I've got some more stuff to share here. Like I said, I did cover another RICO case. It was a federal RICO case involving the Mongols motorcycle gang, and these cases are kind of just inherently gonna take forever. You know, I mean, the Mongols motorcycle gang case was like a 2-month trial, and that was Judge David Carter in federal court in Santa Ana, who ran a really tight ship, and it was like 8 to 4 or 5 testimony every day, 5 days a week, and it still took that amount of time. So looks like they're coming back here, unless no, they're still just going over so they were supposed to start like 20 minutes ago. See if we can find the stream here. I want to make sure I'm not missing it, but when I pull up the law and crime stream, it's still just them. It's the talking heads talking about whatever happened. Yeah, it's the judge explaining herself. One interesting thing that was brought up in my text this morning was the rap lyrics that are coming in. I know that there was some pretrial motion. There's been a lot of coverage over the fact that prosecutors are going to bring in some of Young Thug's rap lyrics to try to show his control over these criminal activities and that kind of thing. So that's an interesting thing to talk about. Let me see. Make sure we're not missing anything here.
Objections as to going forward?
I would go ahead, Mr. Shannon. Your Honor, I understand the court's ruling, previous ruling. Just renew my objection that I think because the state didn't turn these over, they should be excluded.
Mr. Steele?
Yeah, Your Honor, I was unaware that there was a change. I apologize.
I think we're back here.
I told you all to do that during lunch. That was my last conversation with you all before I went ahead and broke for lunch.
Not to do it. We're waiting. Right here. In the hallway and in that other room here. So I understand that the state updating something, not realize that that's what they were doing.
Your Honor, we did indicate that we would be making those corrections.
You know, you all don't listen to the court, and it's going to get you all in a lot of hot water. You need to listen to me when I tell you something, and don't rely upon your own understanding. If you have clarification, ask me at that point in time. I'm more than happy to do that for you. But that's not what I told you all to do during the break. These jurors are waiting back there. We are dallying out here. So, you didn't follow my instructions, Mr. Steele. I mean, that's what I asked you all to do. I asked you all to share each. We're already behind to begin with. So,
what a shit show. Just give up. We all go home.
Any further objections?
Yes, Your Honor, I didn't know that they were changing.
Yes, Ms. D. Williams.
And on slide 10 and 13, they misquoted the Instagram post.
Again, they misquoted it?
Yes, they did. It says, I bet YSL make the news tonight. That's not what the Instagram post says.
Your Honor, we actually copied the Instagram post into slides 10 and 13.
And it does not say tonight.
I'm sorry, okay. I will take out the word tonight. She's right.
No.
Anything further? Mr. Sharp, did you rise to?
Well, I'm just seeking
I, on behalf of, I think, everyone in this back row, we're seeking clarification. Is the state saying that the same link that they sent earlier before the changes will now show an updated version?
In fact, it does. It has on every other person's computer who has this PowerPoint. And at the appropriate time, we would, Mr. Sharp shared his PowerPoint. We were able to see it, and the state has objections to the argument in the slide in Mr. Sharp's PowerPoint that we would like to address before we're in front of the jury.
Yeah, here.
Could you repeat that, Ms. Love, again?
Yes, Judge.
Mr. Harvey can't hear back there.
So the state shared its PowerPoint with all parties, including other members of the state's team and the other members of the state's team that have looked at the PowerPoint. They were able to see in real time the changes that are being made, as are anyone with the link that I shared with the defense earlier. Additionally, Mr. Sharp, over the lunch break, shared for the first time his PowerPoint and has included slides to which the state objects and has responded and told the court and Mr. Sharp that we object to. But I just wanted to make the court aware before we were in front of a jury again, as this, I think, is the appropriate time to do so. But the changes that the state made were available and published to everyone on counsel for the defense team.
All right.
Okay. I think the confusion, Your Honor, I understand what the state's saying now. The confusion is no one on the defense team we were waiting on a new email with a new version of the PowerPoint.
That's not what I told you all to do. I was pretty clear. I said, y'all, over lunch, just take a look at the state's PowerPoint. Make sure you have no further objections. I didn't tell you to email it to you. I just told you to look at it. I don't care how you did it, but that would be the thing I would probably have gone through and said, hey, let me see slide 1, 2, 3, 4, 5, 6, 7, 8, 9, whatever else.
Okay. Yeah, we were waiting. We had voiced some concerns already, and we were waiting on a new version. And I'm just explaining, Your Honor. I don't think anyone was aware that it was being edited on that old link. I think people were waiting on a new version of the PowerPoint.
Okay, here's what I'm going to do. I'm excluding the PowerPoints. Y'all just going to have to make this thing up the whole way. Yeah, just make an opening statement. No PowerPoints. Let's bring our jury in. No PowerPoints, because you all did not do, hold on, I'm starting. You didn't do what I told you to do, and that was to exchange PowerPoints. We have wasted almost 2 hours trying to get this stuff done, and my orders to you are not aspirational. They're given for a reason, and when you don't follow them, then I have a way to remedy that. So the remedy is nobody uses no PowerPoints. Okay.
I could address the court, Matthews and Mr. Huey. In terms of what we have done here on our team, we have provided our opening statement to the state of Georgia, as well as to every other person on the defense side. We have received from the state of Georgia an updated, came to my email from the state of Georgia with the changes as it relates to Mr. Huey. I have it. I will be hamstrung, Your Honor, if I am not able to use my opening statement because I prepared my case with my opening statement. I have not committed every single slide to the memory judge. I'm depending on my opening statement to present to the court, to the jury judge. So I'm asking the court to reconsider its position as it relates to Mr. Huey. Respectfully.
All right. Mr. Steele?
I sent our entire PowerPoint to the state of Georgia last Tuesday.
Which the court has already. I do acknowledge that.
Now I did everything the court demanded.
All right.
So I'd like to use mine.
Okay. All right.
In Your Honor, to be clear, on behalf of Mr. Stillwel, I sent over all the.
When did you send it?
On Friday, I sent all the photos of the exhibits I plan to use or the demonstrations I plan to use, save for one which I did not have physical custody of, which is a Fulton County jail uniform, which I took a picture of. And I have it with me right now. But I did not have that on Friday when I sent that over. I did not have custody of that object. Regarding the PowerPoints, when the state finally handed over their PowerPoint and said that they didn't realize they were supposed to hand over entire PowerPoint or give these exhibits, which they didn't do that either, by the way. I did. I sent them out of an abundance of caution my entire PowerPoint. So.
And Your Honor, I don't object to, generally speaking, the PowerPoints that have been shown. What the state did do was exactly as the court directed during the lunch break, as Mr. Matthews was able to see, we provided to each member of the defense team every change that we made. And respectfully, Your Honor, we would also request that the court allow the state to continue in the path that it has gone. We have complied with the court's directive.
No, you didn't actually. The court's directive was you were supposed to turn this over way beforehand, because then we could have corrected these issues and not spent 2 hours in doing this. I'm deeply disappointed in, because this is exactly what I told you all was going to happen, was that we were going to end up dealing with a lot of objections. And I mean, I don't mind dealing with the objections, but I got to have time to do so. So that's why I told you I had to start having this discussion with you about a week, almost 2 weeks ago. Mr. Steele brought that up, saying, hey, go ahead and turn over your PowerPoints so that we can go ahead and, if the court mentioned, have as smooth as an opening statement as we possibly could. That obviously, very few people adhere to the court's instructions, and we find my words to you a self-fulfilling prophecy, meaning that we are still dealing with this particular issue, and our jurors are waiting on us. So.
Yep.
Your Honor, we have, as well, as I stated, we provided the photographs we intended to use.
When did you provide them?
Friday before 5, Your Honor. The language that is in the PowerPoint are the words, our opening, our things. They all have that. Everyone has that. I don't believe that there is a general objection to that. Every objected to portion of the PowerPoint that the state has, Your Honor, has been modified to address those objections. And just ask the court to allow the parties to proceed as we have been proceeding with respect to presentment of opening statements. Additionally, Your Honor, I am not objecting on the basis of anyone having given the state the PowerPoints today. I'm not objecting as it relates to when anyone gave us the PowerPoints. I only objected to these photographs that were provided to us just a few moments ago on the basis of that they were argumentative. And I want to bring that to the court's attention. If the court decides that they stay in, even though they're argumentative, the state has, we can get past that quite easily. We would just ask that the court allow the parties to proceed as we have.
Are you referring to I'm in possession of 2 emails with photographs, while marked as the next court exhibit in order. One of them is, it has, The subject of the state objects to arguments contained in Shannon Stillwel slides below, and I have a couple of, it has like 3 slides.
Yes.
I'm gonna mark that as the next court exhibit in order.
Yes.
Mr. Sharp, why don't you believe this is objectionable? It would seem to me it's got pictures of a couple of folks here at our facility and a picture that's probably more prejudicial than probative. And it has somebody that's purports to be an inmate. So why wouldn't that be?
I don't think, Your Honor.
Yes.
I don't believe, I'm not seeing the email. I see an email saying the state objects to use of these photographs during opening.
It's got your 4 slides, state's key witnesses, Nicholas Robinson, and then Nicholas Robin, a.k.a. Spencer Wright. Those are 3 that I'm looking at.
It's not showing that in my email. I'm seeing 2 pictures of jail.
I got that one too, which I'll mark as the next court exhibit in order. And that's the 2 pictures that you referred to. And it has the state, subject matter is the state objects to the use of these photographs during opening.
Could I see what we're talking about? Because I don't have it on my email.
Sure.
I'm not seeing
it. Christina, can you mark these in the next court exhibits and then show them to Mr. Sharp? Counselors, you can approach and take a look at it.
And Your Honor, the floor is on the right.
Hang tight.
Yeah, what a cluster. All right, are we gonna have openings later or live? Need a decision, guys. Yeah, probably using Yahoo email. Yeah, or an AOL.com address. Maybe the judge still has an AOL.
Which one did you mark it as so we can?
I have, it's marked Exhibit 2.
All right, courts 2, or next court's exhibit in order. Okay. All right.
And I wasn't on that email, and that's fine. I just wanted you to, that's why I hadn't received it. So this case is going to involve
objectionable.
Well, I'm allowed to preview the evidence that I believe that will come out. I not only believe, but I know that several of the witnesses in the case, which I'm going to discuss in opening, became involved in this case once they were in the Fulton County Jail. They were jail inmates. Okay? Now, I'm allowed to preview the case in that way. To the extent if the state has a particular argument or objection to one of the photos, then we can talk about that. But okay,
court does.
Well, I can alter my.
I mean,
so what is it you want me to alter, Your Honor, to avoid
the picture? And if the state doesn't have an objection to the, you saying anything about any other witnesses in custody, then that's certainly within their purview.
Well, the case law, as I understand it, allows us to preview the case and let the jurors know in advance that witnesses were in custody at the time they made statements. That is completely appropriate as under the law as I understand it. Now, if there's a problem with the pictures, as I said, Your Honor, I will remedy that. That's not a big deal.
I think well, I would ask that you take the pictures out. Okay.
That's fine.
What about the argument in the pictures seem to be, And that would solve that issue. So what about the other issue about the slides?
Well, they also said this Nicholas Robinson one.
Yeah.
I'm not sure what their objection is. I will be letting the jury know, which will come out in evidence, that a man who claimed to be named Nicholas Robinson was arrested on October 19th, 2015. He's an important witness in this case. They will know, the evidence will show that he was interviewed by Detective Thorpe, and he gave his vantage point of where he was, and he told a story which involved the guilt of 5 people that are listed on this slide. And that evidence will come out at trial, and I don't see anything objectionable about this at all.
All right, Ms. Love.
Judge, I don't object to Mr. Sharp telling the jury the words that he has shared with the court. What I object to is the imagery that is depicted in the.
You mean the person that's in a uniform as well as the purported condition of the jail in that lower one?
Well, correct. That's a separate slide.
Huh?
That's a separate slide. These are 2 separate slides. I just want to make clear. These are 2 separate slides. So I'm saying that I'll take out the pictures.
And also the giving of the false information. So the problem that I have, the only problems that I have with the language in the other slide is that part of that information is improper impeachment that Mr. Sharp would not be able to introduce at trial.
Except that.
And I don't have any problem with Mr. Sharp telling the jury that the evidence will show something about Nicholas Robinson, but he has listed all of the arrests for Mr. Wright, Mr. Spencer Wright.
Who is Nicholas Robinson, Your Honor, just so the record's clear. Your Honor, as Your Honor knows, we're allowed to impeach with prior convictions.
They gotta be called first, right?
But we are also able to impeach with bias.
Okay,
And the fact that this gentleman was arrested, Your Honor, that's the central crux of this case, and it's something that the jurors need to be made alert and to look out for as this case is presented. The bottom line is Mr. Wright, who identified himself as Mr. Robinson, was arrested on felony charges and probation violations on 10/19/15. And then he reached out to APD and said he wanted to give information. And then he met with Detective Thorpe. Nothing I'm saying is incorrect. It's all accurate. It all would go to his bias and motive and reasons for coming forward. And
all right, so you're saying this is what he was arrested on the 15th?
Right.
On 10/19/15?
Correct.
Okay, all right. Okay.
And quite honestly, off the top of my head, I don't know how those cases were resolved, but they were biased at the time that he made those
Are
statements.
you saying that because the evidence will show that he then gave information against your client
Yes.
or involving your client?
Yes.
Not sure.
And I don't have a problem with him saying that Mr. Wright was in jail. I don't have a problem with him saying he had open charges. It is the listing of the specific ones that we objected to.
I don't know why that's
Because they are
objection.
not convictions and that is not the proper method.
Yeah,
to
I would
show
agree with that.
bias.
So you can talk about, unless you get them in a proper format, yes, you can talk about if you have criminal charges, that would be appropriate. What happened as a result of that, but I think the longer listing of that, because you said, you don't know what happened to him, so.
But the reason I'm saying that is because I think it's irrelevant because this is really about bias.
It's not proper though. It's not proper format. Bias is fine. You can talk about the.
But he had the bias because he was facing these. Certainly, if someone's arrested for murder,
you just can't mention the individual charges themselves unless they're in the proper format.
I
okay?
understand. But my only point would be, Your Honor, certainly if someone was charged for jaywalking, arrested for jaywalking, and someone else was arrested for murder, the bias, the level of bias would be different. So,
okay, but what does that have to do with them not being in proper format, though?
Because the jury is allowed to understand specifically what bias the person has. Not that they're just in jail, but what they are facing.
If you can get it in the proper format, then it can be, and you can tell them about that. Do you know what happened in these RICO charges?
Well, they
Is
hadn't been
Nicholas
resolved
Robinson going to testify?
at the time that they.
Answer my question. Is Nicholas Robinson going to testify?
If the state doesn't call him, I will.
Okay, well then, at that point, then it might be appropriate for you to get into that specifics. But unless you're going to package that up, and certainly that's not, you can decide that. You don't have any responsibility to present anything on behalf of your client. But in order for you to delve into it, it has to be in a proper format. I would agree with the state with that. I was sustain that objection. But you can talk about arrests, you can talk about pending charges, you can talk about that, you'll present evidence sufficient to show that he's got an axe to grind, he's got bias.
So you're, just for clarification, because I want to get this right, we're saying your instruction is that I can say that he was arrested and he had pending charges, but I just can't say what those charges are.
Until and unless they become you get them in the proper format where you have a witness you can lay a foundation for those. Okay?
Okay, and the third thing, Your Honor, is I have a Fulton County jumpsuit. This is the same uniform, not
Halloween,
actually the same one, but is the same make and model that a number of the state's witnesses were wearing when they inserted themselves into this case. I wish to preview to the jury and say the evidence will show that these individuals were in Fulton County custody wearing this jumpsuit. At this shirt at the time that they gave statements. That's previewing the case. There's nothing objectionable about it. I'm not going to put it on. I'm not going to jump around the table. I'm not going to do anything with it. I'm just going to show them and say this is what they're wearing.
Now,
Judge, I think that is appropriate for argument, but I think that saying and making certainly Mr. Sharp can tell the jury that the evidence will show they were in custody, all that, but that I would argue would be more appropriate for a closing argument. And that is argumentative.
I believe it is appropriate for a closing argument, but I think it's also appropriate for an opening argument. And I'm allowed to use demonstratives to try to get my point across to the jurors in a way that will stick in their mind, because we all know that they're going to be listening to 15 hours of or 10 hours of opening statements and 9 whatever of testimony in this case.
all right, I'm going to sustain that particular objection and also remove ask you to remove that picture of what purports to be I think it's a cell or something like that. So remove
Yes.
those. So yes,
Remove the pictures.
and lose that for the time being. Sure. For the time.
Okay, and take off the specifics.
Take out specifics. Okay.
All right. Thank you, Your Honor.
All right.
Okay, Your Honor, hold on one second.
Oh.
Mr. App, have your client put on his shoes. All right. Anything else? Anybody else?
Your Honor, there was not anything with respect to any of the defendants, but there was a matter
You're gonna get to it?
that probably is best addressed with a member of defense counsel at the bench briefly.
Ooh.
It is a short matter.
Okay.
Defense counsel?
Either one, it really doesn't matter. It's not.
All right. Put your headsets on, please.
Oh, so this is so they don't all have to go up and so many of them can into it from where they are.
They have to also hold it.
What a cluster! Getting a lot of interest. Like I said, I'm doing that Scripps Howard interview for Scripps News.
Can you hear me?
CBS Chicago also reached out. Okay, we're not privy to hearing this. One thing, when they scan the courtroom, I'm surprised at how it looks small, but maybe it's just the angle that we see it at. Definitely a big audience. watching at home, I mean, this is a pretty big one, and the way Law and Crime just makes these trials available to everyone is pretty great. We can just watch the proceedings all we want. Well, you know, they didn't say out loud why they're approaching. The DA said that she has an issue that she wanted to raise with defense counsel at the bench. So then they cut us off. So we don't know what they're talking about up there. It's kind of a bummer. It's always the sidebars are the most annoying part. I just covered a trial in LA federal court of the Conception boat captain. You guys might remember 2019, 4 years ago, off the coast of Santa Barbara, there was a dive boat recreational trip for scuba diving, and it had like 33 people on board and crew members, and there was a fire, and the crew jumped off.
As long as we don't have any other issues.
Thank you.
Okay.
I just covered that. That's all that's really.
Yes, Mr. Steele, what is it?
On the PowerPoint, I'd like you to grab the newest one, and I got the last one. Number 19 is argumentative. Number 41 through 47, 51, and 54 is the law that they take from the court. I would object to those numbers.
And
I believe that the argument about the law was raised prior to lunch.
Hold on. As it pertains to number 9, I'm going to mark the state's second PowerPoint as the next court exhibit in order. In terms of number 19,
that is.
We didn't chase the lyrics and solve the murder. We chased the murder and found the lyrics. Is that what you expect the evidence to show, madam?
Yes, it is.
All right. I'm going to overrule that objection. What's your next one, sir?
41.
41. Judge's rules. All right, this is a note taking that I already gave them.
I didn't change it.
Ms. Lowe, why are we rehashing this since I've already told them that?
Your Honor. Oh, why are we putting it back?
Why are we rehashing that? I just told them that. I told them what was in 41, as well as 42.
Your Honor, I can take them out. I don't mind. I was just, it's part of the opening that I wanted to emphasize, but I can take it out.
I'll sustain it. You can tell. I mean, you can tell them that it's fine. I'll ask that you take out 41 and 42. So I sustain that objection, Mr. Steele.
So
what about 49, 43? Did you have an objection, sir?
Correct.
Your Honor, is the court directing me to take out the picture, or can I just take out the word take notes? Because
no, take notes is fine.
Oh, okay.
He didn't object to that. Okay. He's objecting to 41 and 42, which I'll sustain the objections to that. And then at 43, let me look at it.
Yeah, so the mistrial, I mean, obviously they weren't going to actually grant a mistrial 20 minutes in, but they always say that, the defense needs to do that to preserve the record. But here was more of a forceful mistrial request than the others. Again, it's not like it was actually going to be granted, but to have the DA say, oh, well, we should do a curative instruction because she misstated something or there was something up on the screen that was erroneous in her opening statement. I mean, to have the DA saying we need a curative instruction, like 15, 20 minutes into her opening, it was kind of a big misstep. Like the mistrial was never going to happen, but it was a pretty big screw up.
When they testified, there's some words to that.
Okay.
But the other things I have not instructed the jury as of yet. I had to judge credibility. I didn't give them a preliminary charge on that. So if you could take those out.
Okay.
1 through 7, please.
Yes, Judge.
Does that suffice, Mr. Steele?
And as.
Or do you still have an objection to 43?
Yeah, and I appreciate what you said. I will accept it, but prosecutor opening statement, this is Johnson versus State 261 Georgia Appeal
98 Division 6C as in Colette. Charlie. And Charlie. No, just one, Charlie, okay? Just one. We gave you the military alphabet. It's on your desk.
Stop joking around, dude. Get to work.
I only want the military alphabet, okay? I know. A very sweet lady, okay? All right. So. But it says
Young Thug with some
it should be limited to what the prosecutor expects in evidence to prove a trial. So I don't see why the law is coming into there. That's my objection. I removed 41 and 42.
For clarity's sake, Your Honor, I did and have been editing as the court has directed. So my 41, because I took out a whole slide, may be different. For clarity, the one that the court is referring to is 41. Is that the one where we are saying your assessment of a witness's credibility, blah, 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 all of that?
No transcripts in the jury room.
Okay.
I've already told them that too. So why don't you just do this?
I can take that.
Why don't you just your last slide can be take notes. And you can tell, I think that what you told them, what would be more than proper argument would be, hey, remember what the court told you, and take notes in a way that works best for you, and use whatever memory aid you need. And remember, that would be more than appropriate, and I think would not be objectionable.
So I'm also taking out the one that says, please pay attention. Is that what the court has directed? Because I'm going to hit delete if it is.
Yes, I would take that slide out, okay? Anything else? Can we call for our jurors now?
Please.
45 or the old 45? I don't have the old 45 right here. They've gone through, the new one goes through 43, sir. Okay, as long as it's removed, then yes, I'm satisfied. Okay.
Your Honor, and I want to make sure that we all have everything the same. So just to be absolutely certain, I'm going to share again with the court, because the numbers that I just heard the court reference.
I have the new slide show you sent me, which goes from 1 through, I didn't go down far enough. Okay, all right. The new slideshow goes 1 through 56.
I took out some, yeah.
So I'm going to say take out 41, 42, 43.
And I'm changing them in real time, so I'm taking them out.
What a cluster.
You need to take out 44.
Okay. Is that the one that starts with judge's rules?
No, please pay attention. You need to take out 41, 42, 43, 44, 45, I will leave in over objection. Okay, I'll let you leave in 45 and 46 over objection. 47, judge's rule, 47 needs to come out.
So the one about with the finger pointing, that
finger and the eyes are fine.
Okay. And I took out judge's rules.
Tweeting right now, guys.
And
I always think about
I think I've already taken out 47.
Right there.
47 is judge's rules again.
I took that out.
All times.
Any further objections, Mr. Steele? Because I am going to leave in 45 and 46, okay? But but I'll take out the other ones that you just mentioned.
Okay.
So waiving my mistrial, thank you, sir.
Say again?
I apologize, without waiving my mistrial, thank you, sir.
All right, and so
Without
this motion
waiving.
for mistrial has been denied, and I've noted your objection for the record, sir.
And confirming everyone has 1 through 52 with the edits that the court has directed.
It's on the same old list, right?
Yes, it is.
All right. Anything further? All right. Yes.
Maybe you should.
What are your objections, sir? To the court's, the court's preliminary instructions.
Is your Shannon?
First, before the court talks in terms of guilt and innocence, and I would object to any of the phrases that use the term guilt or innocence. I object to the use of the phrase, the purpose of a trial is to discover the truth. No, it's not. The purpose of a trial is to determine whether the state proves beyond a reasonable doubt the allegations in the indictment. So I object to that.
Sure.
I object to the fact that the court, I believe, is going to allow the jury to frame questions to provide to the court. I was unaware that the court was going to.
No, I'm probably not going to do that, Mr. Steele, Mr. Harvey. I do that because that's part of the pattern charge, the pattern preliminary charge. And most of 9/10 of the time, they're not going to ask any questions. And if they do, I will then present that question to you all for your consideration, and I may or may not ask it. But you objected to it. Okay. Anything else? Okay, all right. And I'll note your objections for purpose of the record, sir. Okay, all right. Can we summon our jurors, please?
Okay. Yeah, that guy who was just talking with the ponytail during the motion hearing that went till like 9:30 at night. He was wearing street clothes, or not a suit at least. And I mean, I hadn't watched too much of it, so I was like, "Is this an attorney?" It looked like it was like just some IT guy for the courts, like wandering around back there. But he suited up today with his ponytail. It'd be interesting to. I bet we're not going to be hearing from him until tomorrow, his opening statement. But I'm not sure the order of the defense opening statements, like who's going to go first. I don't think it's Young Thug. Just from the way it's seated, I think it'd be one of these guys up here. Obviously, there are 6 defendants, so there are 6 lead attorneys, but clearly there are more attorneys than that. I mean, Young Thug has a couple people next to him. I don't know if they're with Brian Steele's office or who the attorney next to him, and maybe some paralegals around. I mean, obviously there's a lot of court staff in there, but they have so many defendants. They've actually got the defense table set up back in the gallery where the audience would usually be seated. Jury's coming in. In LA Superior Court, it's weird and unnecessary, but it's like a tradition where the clerk pounds on the door, like before the jury comes in, and yells "jury entering." They did it in the Southern District of New York too, federal court in Manhattan. They don't do it in like LA federal court. I didn't hear them do it here. It's just like kind of this weird old tradition that's like, why do you need to do that? Like, we know the jury is entering, but it's like court clerk smacks the door and just jury entering. It's like, yeah, we know. They talked about it. There we go. So we're gonna get back to DA Love. What's her first name? Adrienne Love. Get back to her.
Please be seated. We're just going to wait on one. We're waiting on one juror, ladies and gentlemen. Just be made easy. Just a second, please.
I wonder if it's the same one that was late this morning. Chronic late one on her hand. I always think of the court clerk. That court clerk she looks fabulous, by the way. But, I mean, she's just going to have the camera on her at all times. You know? Big spotlight. Yeah, Julie was back there taking a nap. No kidding.
All right, thank you, Sergeant Ingram. All right, ladies and gentlemen, how was your lunch?
No, I'm not
All
sure.
right, good.
They
good.
probably.
Okay. Ladies and gentlemen, before we go ahead and continue with the state's opening statement, I need to kind of just advise you of just something that was said to you earlier, okay? So with your patience, all right? I believe the state council earlier referred to some representation of the parties, and I just want to remind you of two things. Remember that opening statements are not evidence, and that what the attorneys say is not evidence. And with that, Ms. Love, you can continue, okay?
Thank you, Don.
All right.
And thank you, ladies and gentlemen of the jury. I like the court. I hope you all had a great lunch and can stay awake with me for just a few moments more. So where we left off, the crimes that the defendants are accused of committing in this case. You're going to have the indictment with you. It's going to go back. A listing of them includes the following: conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, murder, armed robbery, aggravated assault, possession of a firearm during the commission of a felony, possession of a firearm by a convicted felon, possession of a firearm by a first offender probationer, and death by receiving stolen firearms, among other things. This list is not exhaustive. You will have again with you the indictment, and you are to consider as the state admits verdict. So breaking it down, the evidence is going to show that the defendants, when we say conspiracy, it's nothing elaborate. It's a legal term, which simply means the evidence is going to show that the defendants had an agreement. There will not be a written contract presented to you. There will not be a letter signed in blood by any of the defendants. But what you will see evidence of is the defendants' actions, their presence, their companionship, their conduct before, during, and after a long list of crimes. And what you will see is that the defendants weren't always convicted of these crimes. Sometimes the state no-crossed or dismissed charges. Sometimes the police never brought formal charges. But what the evidence will show is that the defendants did commit those crimes. And when we're talking about a conspiracy, an agreement, just an agreement, unspoken agreement, we're gonna participate in YSL through a pattern of racketeering activity. That's another large word that is used in the legal community, but regular folks, myself included, just don't generally tend to use it. Racketeering activity is nothing more than certain crimes, the crimes that are listed out in the indictment. You will see that, and the court will instruct you, I expect, that those crimes constitute racketeering activity. And as I stated before you all broke for lunch, a conspiracy requires just one overt act. So you will see evidence of several overt acts. Several acts that were done by these defendants and by unnamed and unindicted people as well, to further the interests, to further the goal of the conspiracy that the defendants participated in. You will see overt acts meant to establish YSL's dominance and control. You will see overt acts meant to gain illegally access to money and wealth and property that did not belong to YSL. You will see overt acts, steps taken on the part of various individuals to act to protect the group as a whole. Steps that have nothing to do with a recording label. Steps that have nothing to do with an A&R executive. You will see steps that were taken solely for the purpose of illegally gaining goods for and on the behalf of YSL and its members. You will see steps taken by each of the defendants to protect the members of YSL, to establish the dominance and control of YSL. Nothing in what I expect the court will tell you, nothing in the evidence will suggest that any of the defendants had to be convicted of all of the overt acts in order for you to see that they actually had an agreement. The acts don't even have to be crimes, but they are. And that is how the state expects you will know that these defendants, they wanted to participate in this enterprise. They wanted to participate in this organization through these illegal acts. They wanted to obtain ill-gotten goods that they did not have a right to have through robbery, through stealing, through drug sales, and the like. So we'll start off by looking at the defendants. 6 of them are at the table, and 6 of them are here for you all to decide, has the state proven its case? Rodalius Ryan. Rodalius Ryan is one of those people whose youth and life was swallowed up in the crater created by YSL in the Cleveland Avenue community. The evidence is going to show that in 2019, Rodalius Ryan was 15 years old. And that in February of 2019, Rodalius Ryan used female acquaintances to lure Jamari Holmes to a particular address here in Fulton County. The female acquaintance lured Jamari Holmes to that address, telling Jamari that he would get sex and weed once they got there. Instead, when they got to the address, the female gets out of the car and the defendant, Rodalius Ryan, and his accomplice, Deamonte Blaylock, also a YSL member and associate, they then came out to the car with guns. The evidence will show that Rodalius Ryan and Deamonte Blaylock then fired those guns into the car, where Jamari Holmes, not even 20 years old, was seated and hit him in the back of the head with a bullet that took his life. Jamari Holmes is another one of those young lives, the evidence will show, that was swallowed up by the crater that YSL created and left in the middle of the Cleveland Avenue community in Fulton County. 12 hours after shooting and killing 19-year-old Jamari Holmes, the evidence will show that Rodalius Ryan doesn't say, I bet I make the news. Rodalius Ryan posts on his Instagram account, I bet YSL makes the news. The evidence will show that in posting about YSL as it related to his flagrant, overt act of extreme violence, Rodalius Ryan was agreeing to and attempting to participate in YSL through this illegal activity. He was promoting the gang. He was showing their dominance. He was showing their power, and he was showing their control. Rodney Uten was also in the car with Jamari Holmes. That's another young life. He wasn't taken, he survived. But he was forever changed by the acts of YSL, conducting and committing violence on behalf of the entire organization. And in case it hasn't been lost on you, Rodalius Ryan's Instagram handle that he used, Slime Business Ride. Because as the evidence will show, slime is spoken and used to signify doing someone dirt. And Rodalius Ryan is proudly proclaiming his association with YSL as he talks about and as he promotes the gang itself. Rodalius Ryan's accomplice, another YSL member who's not here today, but who is a co-conspirator. What did he post after they killed Jamari Holmes? The evidence will show that Damone Blaylock didn't say friendship over females. He didn't say Blaylock over buddies. He said slime over sluts.
Ooh.
Slime over sluts while posting a YSL gang hand sign with the caption slime over sluts, a green heart emoji, and a green snake emoji, which I expect the evidence will show are the common identifiers associated with YSL. They're the identifiers that they use to announce and project themselves to the rest of the world. And then, on February the 25th, 2019, Rodalius Ryan made another posting where he's flashing cash money on his Instagram page with the caption, "Fuck YFN." YFN being a rival criminal street gang. The evidence will show that none of this was a part of what anybody has to do to be a part of a record label. The evidence will show that these acts were done in furtherance of and to promote the goals of the enterprise, the criminal street gang that is Young Slime Life. And what did the paper say? 15-year-old, they called Jamari Holmes a known gang member, but the evidence is going to show that that's not who he was to the people who cared about him most. Jamari Holmes was Jamari Holmes. He was a baby, a child, found shot to death inside a stolen car, police said. Jamari Holmes was just the latest victim of YSL's quest to maintain and retain dominance and control of the Cleveland Avenue community. Again, Rodalius Ryan didn't post, "I bet I make the news." He said, "I bet YSL makes the news." Marquavius Huey, he's also on trial for you to determine whether the state has met its burden of proving he committed the acts that are listed in this indictment. Marquavius Huey showed his agreement to participate in the activities of YSL through a pattern of racketeering activities. He showed his willingness to commit acts on behalf of the gang through his actions. The stolen handgun he had, that was the property of Jeremy Smith. Because as you will see throughout this trial, stolen handguns will become a reoccurring theme. There's no need for a legitimate organization not comprised of people committing crimes on behalf of the organization to have all these stolen handguns. Everybody has a right to have a gun, so if you're legitimate, just go get one. But the evidence will show that in this case,
legitimate, just go get one.
YSL members, stolen handguns every time you turn around. And not just stolen handguns. The evidence will show that most recently in May of 2022, where some of these defendants were found at the home of Jeffrey Williams, their leader, it wasn't just stolen handguns that YSL dealt with. It was machine guns. You'll hear evidence that at the home of Jeffrey Williams, in addition to the pharmacy full of drugs, that there is a gun with a switch that allows, with one trigger pull, 10 times more bullets to come out at a time than if you just had a regular gun. There will be no evidence to show any need for that in legitimate, ordinary, record deal making business. The evidence will show that the existence of those dangerous weapons like the machine gun, the stolen firearms, those things are all evidence of these defendants' conspiracy. Those things are all evidence of the existence of the enterprise known as YSL, whose goal it is to maintain and
Now it feels like
retain
she's
dominance, control, and ill-gotten gains. Marquavius Huey, on April the 26th of 2019, further showed by his actions, showed his agreement to participate in YSL through a pattern of racketeering activity, illegal activity. When he took the property, jewelry, money, and a debit card of Dewan Maynard by use of a firearm. Dewan Maynard, another life affected by this crater created by YSL in the middle of the Cleveland Avenue community. Marquavius Huey showed his agreement to participate in this enterprise when he struck Maynard in the face with that gun that he used to take Mr. Maynard's belongings. Marquavius Huey hijacked on October 1st of 2020 a Buick LaCrosse from yet another victim of YSL's violence, Gary Holloman, by force in violation of the law. Mr. Holloman has since passed away, not from that incident. So he won't be here to tell you what he was feeling and how he was able to tell the police who it was that committed this armed robbery. What you will hear evidence of is the extraction from Marquavius Huey's phone, where he's planning the armed robbery, where he set up with Mr. Holloman a ruse so that he could have the opportunity, along with another uncharged, unfound individual, so he could have the opportunity to put a gun in Mr. Holloman's face and rob him. What Marquavius Huey did was kind of slimy, the evidence will show. He told Mr. Holloman, hey, your nephew in the Fulton County Jail, Quamarvious Nichols, he needs some money on his books. So he wants me to meet with you to get money to put on his books. So Mr. Holloman, because he loves his nephew, and any friend of his nephew coming to him that way is legit, right? The evidence will show that Mr. Holloman arrives intending to meet the person so that he could give to them the money for his nephew. And to his shock and horror, he's met with the butt of a gun. 2 people, one with a long gun, one with a handgun, demanding his money. And that day, as the evidence will show, Mr. Holloman wasn't the only person affected by the violence perpetuated every day by YSL. Deamonte Coppage, she just happened to be on scene. She just happened to be right there conversing with and talking to Mr. Holloman when the defendant and his accomplice came up, held them at gunpoint, and demanded their belongings. You'll hear how they directed Deamonte Coppage to just sit on the ground, just give me your stuff. You'll hear how they robbed Deamonte Coppage at gunpoint. The evidence is going to show Mr. Huey's tight relationship with their leader, Jeffrey Williams. The evidence will show that Mr. Huey, on various occasions, checked in with, reached out to Mr. Williams to see, hey, I got this stolen item. You want first dibs on it? Marquavius Huey's actions that betrayed his agreement to participate in the conspiracy didn't stop with Gary Holloman and Deamonte Coppage. The evidence will show that in November of 2020, he made terroristic threats towards Justice Woodard after Woodard told Mr. Huey she'd see him in court. He said, you will die if you put the police on me.
Ooh.
Showing their association, showing their agreement, showing their intention to participate in this organization, this enterprise through a pattern of racketeering activity. The evidence will show that while fellow associate Quamarvious Nichols was an inmate at the Fulton County Jail, Mr. Mender, Mr. Huey, and Mr. Williams conducted a recorded video call wherein Mender relays he needed something and Williams pointed to Mr. Huey to take care of it. And then flashed Mender the YSL sign. You see, it's not a crime to flash a YSL sign. The evidence is going to show it's not a crime to participate in a video call. The evidence is going to show that it is not a crime to endeavor to provide something for a friend who's locked up in jail. All of that is okay. These acts aren't listed on the indictment because they're crimes. They're listed because they are actions. Actions that the legalese for is overt acts that reflect each of these defendants' tacit or unspoken agreement to participate in this enterprise through a pattern of racketeering activity, to be a part of this group, to gain ill-gotten goods through crimes listed in this indictment. I don't even have to use the word racketeering. I don't even have to use the word conspiracy. They endeavored to do some illegal stuff to get a bunch of stuff that didn't belong to them. and somebody, more than one, but all we need is one, the evidence will show that at least one person took a step towards furthering that goal. So when you get the indictment, after however long it takes us to get there, and you're looking at 191 acts and thinking,
91.
state, really?
I sustain the objection.
Thank you, Judge. I'm
Move
moving
on, move on. That's argument.
The evidence is going to show that these steps that they took are akin to you just going out and get some toilet paper to further a conspiracy to go TP a house. Doesn't have to be a crime. It's just an act, an action. The evidence is going to show that the defendant Jeffrey Williams' words and actions also betray his participation in the conspiracy. I expect that you will hear from a YSL associate and member at trial that the defendant Jeffrey Williams rented a car, notwithstanding that Jeffrey Williams had his own cars, but he rented a car which happened to be a silver Infiniti sedan that other YSL members, among them Deamonte, Kendrick, and Shannon Stillwel, used when they openly and notoriously gunned down Donovan Thomas on January the 10th of 2015. The evidence will show that after that horrific act, I expect yet another YSL associate will come in here and tell you that Jeffrey Williams paid them money, gave them money to go to Miami and lay low in the wake of the Donovan Thomas murder.
You gotta lay low.
Later that month, on January the 26th of 2015, Deamonte Garlington, who isn't before you for your consideration today, but who is in fact a YSL associate and co-conspirator of these defendants, he posted a video of the defendant Jeffrey Williams looking into the camera and saying these words. So, I think lie to their mama, lie to their kids, lie to their brothers and sisters, and then get right into the courtroom and tell the God's honest truth. Don't get it. Y'all need to get fucking killed, bro. That's from me and YSL. The defendant's words tell you that there is an enterprise. The defendant's words establish his willingness and agreement to participate in this enterprise through illegal activities. He didn't say that's for me. He said that's for me and YSL. And as the evidence will show, that's akin to him saying that's for me and my pack. Kendrick's and Williams' words, there's been a lot of talk about lyrics. But y'all, the evidence are gonna show in this case, we didn't chase any lyrics to solve any murders. Law enforcement in Fulton County chased the murders and found the lyrics. They're investigating, they're finding out who committed it. And after doing all of that, they happen upon lyrics. Lyrics that have an uncanny similarity to very true and very real and quite specific events, as the evidence will show. Jeffrey Williams' words that he promotes through songs with beats behind them, they aren't random. He tells you, as the evidence will show, take this shit to motherfucking trial. I rep my life for real. For slimes, you know I kill. Trial, I done beat it twice, Kendrick's. I'm undefeated, like feds came and snatched me. I don't know, no point in asking. I was on what? Bleeding. Stuck like a magnet, bitch ass nigga. I shoot at your man, you need to stand down. I up my stamina, take it to trial. Get an appeal, take it to trial. Yeah, you're gonna whack them. Pay for that casket, that's just if we whack them. My young niggas pulling up. Bentleys, Austin Martins, Rares and Teslas strapped with an FN. You're gonna hear a lot about FNs. FNs galore. From here to 2015, FNs all throughout the incidents that are involving gang members YSL. Watch me whack that bitch, pop him like a cyst, Glock with the assist. Incidentally, the gun at the home of Jeffrey Williams on May of 2022 that had been modified with that switch, it was a Glock. Again, we didn't chase the murders. We didn't chase the lyrics, rather to solve the murders. We chased the murders, as the evidence will show, and in the process, we just found the lyrics. Jeffrey Williams' words and actions further reflect his agreement to participate in this organization through this criminal activity. He tells you, we committing them crimes. Hop out and shoot. Roll one up for the gang. He's not using gang colloquially. The evidence will show he's telling you they are a gang. You want to be slime? Children of Fulton County, go catch you a body. Me and little bro. The evidence.
How would you expect the evidence to show, madam?
It is indeed, Your Honor.
All right, I will rule the objection.
The evidence will show that when Jeffrey Williams is saying me and little bro, we used to steal from the store, we had to stick it and go. He's talking about himself. The evidence will show that this is the man, through the music, that he has been blessed with the opportunity to be able to release and gain wealth from. Through that music, through that blessing, the evidence will show that Jeffrey Williams led the group of people that wreaked utter havoc on Fulton County. Jeffrey Williams' words and actions, as the evidence will show to the members of his gang, you'll hear in a conversation he has with them, y'all ain't beat him up or shot him yet, y'all he's getting soft. The evidence will show that there's no place or need for that kind of edict or statement when all you're doing is making music. And to clarify and put a very clear and fine point on it, the evidence will show that no one is attempting to take away from Mr. Williams the fact that he has had a lucrative rap career. The evidence is simply being put before you to show that he is guilty of committing the crimes that are laid out in this indictment. That he and his fellow YSL gang members and associates on trial before you now agreed to participate in this organization through the illicit, illegal activity listed in this indictment. And that they further committed all the other crimes listed in the indictment beyond count one. Because as you'll see, count one consists of 191 overt acts. Acts that aren't all crimes, they're just acts. But counts 2 through 65, the ones that have these defendants' names on them, are the ones you're here to evaluate whether or not the state has proved. Actions and words and actions. The evidence will show that this was Donovan Thomas in life, that on January 10th at 2:15, about 7 o'clock in the evening, Donovan Thomas was living his best life. He was up at the barber shop at 330 McDaniel Street. He had paid for a bunch of people, a bunch of kids to get their hair cut. And you'll see that he is out there enjoying himself. The last actions that he took while he was fully alive and healthy, joking with his friends. You'll see that they didn't even see it coming. You'll see evidence that Donovan Thomas was literally in the middle of laughing it up with his friends when a car drives by and opens fire on him and whoever else might have been in close proximity to him. The evidence will show that this act wasn't done secretly, it was done openly, notoriously, almost as if to send a message. We did it. The evidence will show everybody knew who did it, because it wasn't done secretly. The evidence will show that this act didn't happen in a vacuum. There were things that led up to it. An argument at Club Crucial or Club Brucial, as my defendants may like to say, that involved a YSL associate by the name of Kenneth Copeland and a member of a rival gang. Kenneth Copeland gets jumped. He's flashing money because that's what they do. It's ladies fight night and they're out there flashing money. Kenneth Copeland gets jumped. Deamonte Kendrick jumps into action, goes to Kenneth Copeland's defense, punches out a member of the opposition, and then shots are fired. Shell casings. Shell casings are all throughout the evidence that you'll see and hear in this case. Remnants of the violence inflicted on this county by YSL and its actions. Shell casings are fired in between January the 6th and 7th of 2015 and January the 10th. Other incidents take place and may lead to the ultimate gunning down of Donovan Thomas. As the evidence will show, in the ensuing months, there were series of shootings and retaliatory shootings. Most notably, the mother of rapper Rayshawn Bennett gets shot. Her house is shot up twice. She gets shot one time. And the evidence will show that there is not always cooperation, because there is a code that people adhere to when this type of violence is surrounding them. No snitching. So the evidence will show that even as people were getting shot, even as people were bleeding, even as people were being taken to the hospital to have their wounds attended to, they weren't always forthcoming. They weren't always willing to talk to and to trust law enforcement, not even if it would serve their own purposes. The evidence will show that members of YSL ultimately, as a result of those shootings and retaliatory shootings, ballistics or firearms matches started coming back to various people. And then one YSL member, Quamarvious Zachary, he gets caught with a gun. The shell casings from that gun go to match some of these shootings. Quamarvious Zachary is caught. He starts telling. The evidence will show that Quamarvious Zachary was a straw purchaser for YSL. A straw purchaser is nothing more than somebody who goes and gets guns for somebody who's not supposed to have them. And that's what Quamarvious Zachary did. Firearms found in the hands of Kenneth Copeland led to further revelations to the police and law enforcement. The evidence will show members of YSL were so eager, so gangster about acting on behalf of and in the protection of the defendant Jeffrey Williams and YSL, that when Wayne Carter, otherwise known as Lil Wayne, came to town to perform at the compound while the defendant Jeffrey Williams was performing in Lil Wayne's hometown, according to word from the people that talk, getting booed at the time, members of YSL show up at the compound, locked and loaded with guns. Evidence will show that security knew to be on the lookout for members of YSL. The authorities were alerted to ongoing public risks and back and forth between the defendant, Jeffrey Williams, and members of his gang, and statements being made publicly on social media about, towards, and threatening Wayne Carter. So when Tyrone Dennis, who is working an extra job, he is a law enforcement officer. At the time, he was an investigator with the Atlanta Police Department gang unit. So when he's there working his extra job, and he sees Walter Murphy, one of the founding members of YSL, show up with the defendant's sisters and Trontavious Stevens, and ultimately Jimmy Winfrey with guns. When he sees Walter Murphy try to secret a gun underneath the wheel well of a car, he calls him out. He's like, "What are you doing?" Walter Murphy's like, "Oh, hey. The evidence will show that the YSL gang members that showed up at the compound that night were not allowed entry into Lil Wayne's concert, his venue. So what they did was they waited until Lil Wayne leaves, gets in his tour bus, and is attempting to leave the area. They get up beside the tour bus and they unload bullets into the man's tour bus. Bullets. For nothing, except to show their dominance. There will be no evidence that Lil Wayne threatened either of them that night. But that act on the part of Jimmy Winfrey and the defendants before you today, that act was intended to show their solidarity, their willingness to act on the behalf of, their willingness to exact violence upon anyone who threatened the position of the criminal street gang calling itself Young Slimelight. You'll hear evidence that after being arrested, or actually when he was approached back in 2014 about an armed robbery he allegedly committed, YSL member and associate Trontavious Stevens was seen bearing tattoos on his hands, ROCCREW, Cleveland Avenue. And that on his side, he had YSL. And Detective Mark Belknap inquired of him, "What's that?" Though Belknap knew, because he had been working in the streets of Atlanta for a long time. He was familiar with Right Group. But as gang investigators, they're taught to interact with and talk to people when they see indicia of criminal street gang activity. You'll hear that Trontavious Stevens Toll belt now. Well, Rock Crew is the name we used to call ourselves. Then we started going by YSL, which stands for Young Slime Life, or it did stand for Young Slime Life. But then, when my friend Jeffrey Williams started becoming successful, we changed that name to Young Successful Life. The words of a member of the gang himself. The only time, as the evidence will show, that members of YSL don't want to call themselves and acknowledge that they are in fact a gang is when it would be to their detriment. The evidence will show that any other day of the week, they are loudly and proudly promoting their criminal activities. Donovan Thomas, he was driving this Chevrolet Tahoe the night he was gunned down. The evidence will show that this location here is the barbershop right up from the Texaco at the corner of McDaniel and Northside Drive in Atlanta, Fulton County. We asked you during voir dire, you heard us say, how many of you are familiar with this area? This is that area. The evidence will show that that is the way that Donovan Thomas looked last time his loved ones saw him. That his life was swallowed up in that crater created by YSL in the Cleveland Avenue community. And the words that they found while looking into this murder, spoken by members of YSL. We don't speak about shit on wax, but indeed they do, as the evidence will show. They just kind of thinly veil it. We are known to kill the biggest cats of all kitties. Donovan Thomas in the community, he was a big homie. He was a friend to a lot of people. He was a big deal. And it touched a lot of people, as the evidence will show, when his life was taken. The words that were spoken, we known to kill the biggest cats of all kitties. How coincidental that Donovan Thomas was gunned down. And these were the words later spoken by members of YSL. The evidence will show that it's not coincidental at all. 100 rounds in a Tahoe. 100 rounds in a Tahoe. The evidence will show that the lyrics released by YSL members, the lyrics they chose to speak, they bore a very eerie significance to real life. 100 rounds in a Tahoe. And you'll see that Donovan Thomas's Tahoe had bullet defects all along the back of it when they sprayed Donovan Thomas and his car on January the 10th of 2015. This is that slime shit, killing 12 shit. The evidence will show that 12 is the word that is commonly used to denote law enforcement. And speaking of the young people whose innocence and whose lives were swallowed up by that crater created by YSL, Christian Appinger. He's not before you today, but he is a co-conspirator of these defendants. He is a YSL member and associate who got YSL tattooed on his face at the tender age of 15. He repped YSL continuously and notoriously throughout his social media. The evidence will show that at the age of 16, he, along with an accomplice, robbed a young woman by the name of Taradia Hill at gunpoint in front of her child. And that at his sentencing hearing, Taradia Hill, seeing a young black boy who could have been her brother, cousin, she actually advocated for Christian Appinger's lenient sentencing. So Christian Eppinger, he wasn't sentenced on what he was originally charged with. With the acquiescence of the victim, Christian Eppinger received a lesser sentence. He went to prison for a short time, and within less than a year, he committed an armed robbery. And when law enforcement officers are out there looking for Christian Eppinger, who incidentally constantly posted on social media with guns and his gang signs and the green emojis with the gun pointing to the camera or to some other emoji talking about how he reps hard for YSL. When law enforcement officers, specifically a law enforcement officer just 30 years old by the name of Officer Rogers, when they go to apprehend Christian Eppinger on this armed robbery he committed after being released from prison, having robbed Taravia Hill, they do everything they can to take him in without causing any harm to Christian Eppinger. But you will see that while he's being taken into custody, what Christian Eppinger does, he takes the firearm of this young officer. He pulls it out of the holster and he fires, putting 7 bullets in Officer Rogers. The evidence will show leaving a law enforcement officer with PTSD after he is tried to humanely apprehend a member of YSL. The evidence will show that this person depicted here is Quamarvious Greer, also an associate, but perhaps more importantly, the brother of the defendant, Jeffrey Williams. Christian Eppinger was so deeply entrenched, ingrained with loyal to YSL, he's even posting free bitch as Quamarvious Greer served a sentence for murder. Who said they want smoke? Christian Eppinger, as he's calling himself YSL Briss. Note that Chris does not start with the letter B, but it does when you're associating yourself with a criminal street gang who aligns itself with the Bloods. And that's the tattoo that Christian Eppinger on the side of his face proudly publicized on June 27, 2015. He wasn't even 16 yet. New ink with the green snake emoji and a red heart. The evidence will show that though you will hear over and over the names of the 6 people on trial before you today, that the 6 people on trial before you are not the people who were most viciously affected by the acts of this criminal street gang. The evidence will show how far members of YSL are and were willing to go to act immediately on behalf of each other. Dexter Montgomery, minding his business, happened to drive in just a little too closely behind another YSL associate, who then phoned up the gang who's posted up at the trap house. And in minutes, 2 more YSL associates showed up with a long gun and handguns. Dexter Montgomery had no idea he was about to lose half of his head that day. As Dexter Montgomery left the gas station, 2 YSL associates followed behind him. And as he stopped at a red light, they opened fire. Miraculously, the evidence will show that Dexter Montgomery survived, but literally half of his head is gone. You'll hear from and see Dexter Montgomery during the course of this trial. The evidence will show that after that happened,
That'll be some testimony.
law enforcement, at first it wasn't the gang unit, but the gang unit recognized some of the players, Walter Murphy, other members of YSL. And so they began to assist in the investigation. And they learned the YSL gang members said, we got a call that one of us needed some help. He didn't know who this was pulling up behind him, so we just responded. You'll hear that investigators, Gaither and Dennis, said, well, wait a minute, did you know what you were responding to? They're like, no, we don't have to know. If our boy needs help, we're gonna respond. They said, well, where'd you get the gun? Oh, they're by the door of the trap house that we were in. They're just there, ready for us to use when we need to. Their words, I can't make it up. The evidence will show that actions of YSL, gang members, and associates,
I'm not sure.
on behalf of their leader, when
Probably
they felt
4:30.
someone disrespected Jeffrey Williams or any other member of their pack, they made threats. Not quiet, whisper threats, loud, public threats with wide, vivid displays of firearms. We're not going back and forth. This about to be some Biggie and Tupac shit and shooting up Wayne Carter's tour bus. The evidence will show that all of those actions, they're not elements of the offenses that are charged in the indictment. We don't have to show those things in order for you to find them guilty, but the evidence will show that those things prove the existence of the conspiracy, of the agreement itself. The agreement on the part of these defendants and other charged and uncharged co-conspirators to be a part of this organization known as Young Slime Life through a pattern of this illegal activity outlined in the indictment. There are numerous victims that you're going to hear about. Shannon Stillwel is another defendant who is before you, being accused of various crimes in this indictment. Shannon Stillwel is alleged by one of his own crew, by another YSL, two other YSL members, to have been one of the gunmen who took the life of Donovan Thomas. The evidence will show that Shannon Stillwel was arrested. He was arrested after some investigation by the Atlanta Police Department. The evidence will show that the information initially relied on by that first arresting officer, it didn't pan out to be actually accurate. So when the case got to the district attorney's office, more investigation was conducted. The evidence will show that the office didn't just take the word of the person who originally identified certain people as having committed the murder of Donovan Thomas. Instead, as the evidence will show, what our office did was dig to find out whether the people who were talking were actually in a position and a place to know the stuff that they talked about. And what they learned was that that person originally relied on by Investigator Thorpe, that person was just lying. And so the people that Investigator Thorpe originally arrested on the Donovan Thomas murder, they were released at various times on bond as the office continued to investigate further. The evidence will show that our office did not just stop at the word of one YSL member. The evidence will show that yet another accomplice corroborated the words of the first YSL member that talked. The evidence will show that cell phone records further corroborated the information law enforcement was getting from these people. And ultimately, Shannon Stillwel, Deamonte Kendrick, Justin Cobb, Javoris Bradford, they were all indicted in this particular instrument that you'll have for your consideration. But the only two people who are in front of you for you now to determine whether or not state has met his burden are Deamonte Kendrick and Shannon Stillwel as it relates to Donovan Thomas's murder. However, between the time that this indictment came down and the time that our office decided, no, we need to look into this investigation some more, Shannon Stillwel was released from jail. But he had to wear an ankle monitor as a condition of his bond. The evidence will show.
Thanks for tuning in. I'm just tweeting over here. Don't mind me.
During the time in 2015, after a lot of arrests were made following the murder of Donovan Thomas, that the violence in Fulton County, the gun violence that had continued over the course of that year, it kind of subsided a little bit.
Basis. I sustain the objection.
Yeah, no, I totally agree. Like,
Yes, Your Honor.
she'll get to the evidence and then
The
she
evidence
goes
will
into this
show
narrative. It's like, don't.
That around 2019, 2020, law enforcement investigators, they started noticing some activity on the part of gang members. They started paying particular attention. One of those investigators was investigator Marissa Vigarito. You'll see and hear from investigator Vigarito, and you'll learn that one of her jobs as a law enforcement officer, one of her background experiences was that she was a probation officer, so she had a lot of information about a lot of YSL gang members. You'll hear that initially, after Shamel Drinks was gunned down, Detective Hogan with the Atlanta Police Department, he didn't have any leads. As a matter of fact, he came back to the precinct lamenting the fact that he had no leads on this homicide that just occurred at Windsor and the I-20 entrance ramp. Young man killed, gunned down inside his car. When investigator Vigarito began talking to Detective Hogan, she saw that Detective Hogan did have some footage from the gas station right up from that location. And that investigator Hogan was looking to find the people in the gas station because that gas station was the last place that Shamel Drinks was seen alive. One of the people in the surveillance footage was wearing a very distinct hoodie and coat. And as it would happen, investigator Vigarito had hours earlier been at a Waters Road location, one of YSL's hangouts, as the evidence will show a place from which they conducted transactions, and that the Waters Road address had been shot up, and investigator Vigarito happened upon Shannon Stillwel and other members of YSL in the same outfit he was seen in the surveillance video on at the time Shamel Drinks was inside the gas station. The evidence will show that further investigation revealed that Shannon Stillwel was wearing an ankle monitor at the time that Shamel Drinks was gunned down. And that ankle monitor put him right there at the place that Shamel Drinks took his last breath. The evidence will show that in this murder, much like in the Donovan Thomas murder, there was a rental car involved. A rental car which these defendants had gone and gotten the windows blacked out, tinted on, earlier the day that Shamel Drinks was gunned down. Tinted the windows of a rental car. The evidence will show that it was to evade being seen by the opposition. The evidence will show that as a result of all of this violence and activity, during the midst of it all, Investigator Vigorito had secured a wiretap for Deamonte Robinson, YSL gang member and associate. She was able to listen and detect hours of the goings on of the enterprise. She learned throughout the course of her own investigation and during her time looking into YSL that a rival gang member, Rayshawn Bennett, ended up at the Fulton County Jail at the same time YSL gang member Jaden Myrick was there. The evidence will show that Jaden Myrick, upon seeing Lucci, reaches out to get permission from King Slime to take Lucci out.
King Slime.
The evidence will show that Jaden Myrick actually endeavored to stab Rayshawn Bennett to death, but that he was unsuccessful. The evidence will further show that Jaden Myrick wasn't the only one reaching out to this defendant, Jeffrey Williams, for permission to commit a homicide. Looking at Shannon Stillwell's words along with his actions, happening upon the lyrics while trying to solve the murder, the evidence will show that law enforcement found one nugget spoken by Shannon Stillwell. I just beat a murder rap, paid my lawyer $30 for that. After he was released on bond for the murder of Donovan Thomas, and before he actually took the life of Shamel Drinks. The evidence will show that the young man on the left is Shamel Drinks in life. And that the photograph on the right is what was left of Shamel Drinks after YSL and the crater it created in the middle of the Cleveland Avenue community took that life from his family, friends, and loved ones. I said a lot, and I'm not the only one you get to hear from today. So you might be happy, I'm about to sit down. I want to ask you to make use of those notepads and those pencils that you have in your possession. The court's already given you the instruction, take notes. Rely on your memory.
Okay, we're almost done here, it sounds like.
Use the notes to document and help you remember after you've heard weeks and weeks and weeks and scores of witnesses who said what. I expect that as you listen to and evaluate witnesses who come in to testify, there will be witnesses who you discover changed their stories from the time they first made a statement to the time they actually have to appear here in court, in public, and telling folks I expect that the evidence will show that there are some witnesses you will assess are just scared. Some are embarrassed, some are intimidated, some don't want to remember, some just plain don't remember. The court alone gives you the law on how to deal with and how to assess those witnesses. I only ask that you follow closely the instructions that the court gives you. Look at who the witnesses are. Look at who they look at while they're on the stand. They don't look at or won't look at while on the stand. Look at how they answer questions posed to them from the state versus questions posed to them from the defense. And if the occasion arises that you find that a witness, as presented in court, says something different than what they said previously, you determine why it is you believe that they said something different once they got in court. Words and actions. The defendant's actions coupled with their words. They prove the existence of the enterprise. Their actions and their words, the evidence will show, proves their agreement to participate in this enterprise through these illegal activities outlined in the indictment. Preserving, protecting, enhancing the reputation, power, and territory of the enterprise through acts including murder, assault, and threats of violence are what the evidence will show these defendants did over the last 10 years. The evidence will show that the violence didn't stop in 2015. Preserving, protecting, and enhancing the reputation, power, territory of the enterprise by the posting of messages, images, videos, and songs demonstrating their allegiance to the enterprise and a willingness to engage in violence on its behalf are what you'll see evidence of over the course of the next several weeks. Maintaining armed individuals, ready and willing to preserve, protect, and enhance the reputation, power, and territory of the enterprise through the use of violence. It's what the witnesses and the evidence you will see proves to you. Obtaining money and other property through illegal activities like robbery, theft, and illegal drug sales and distribution. And obstructing law enforcement, killing 12 shit. Investigations and court proceedings through witness intimidation and attacks upon law enforcement officers. You'll see it for yourself. The children whose innocence this organization claimed as its own. And in the end, the evidence is going to show you that YSL is a RICO enterprise, nothing fancy about it. The evidence is going to show you that it's also a criminal street gang. Those two are not mutually exclusive. That these defendants participated in this enterprise in a way that had nothing at all to do with the record label, except maybe their actions as reflected in their songs made their music more real and perhaps more appealing to somebody. The evidence will show that the defendants, they talk about YSL while they talk about the crimes they committed. And while they talk about the crimes they're going to commit, you'll see that this evidence proves that YSL is a criminal organization. The defendants have been associating together for many years, committing crimes together against the general public, against rival gang members, as the evidence will show, against law enforcement, and against each other. The evidence will show they agreed, they willingly participated in these activities. In the end, the court has told you and will tell you again that you are to evaluate the evidence and apply that the law of the court gives to you to that evidence and render a verdict that speaks the truth. I expect that at the close of this evidence, you'll see that the defendant's presence, companionship, and conduct during all of these illegal activities, their words and their actions, not only show the existence of the criminal enterprise called YSL, it also shows the conspiracy. And in the end, we're gonna all come back and make our arguments to you. But the one thing that I'm gonna be doing,
All right.
our team will be doing, is asking you to uphold your duty and render a verdict, the only verdict that speaks the truth, and find these defendants guilty of each and every crime listed on this indictment alleged against them. Thank you.
It's over. Thank God. Okay. Did you do a break or?
Ladies and gentlemen, we've been going a minute. You want to take a comfort break? Anyone? All it takes is one, Okay, all right. 2, see, and then everybody else will go after that. Let's take 10 minutes, and then whoever next would like to make an opening statement, I'll offer that to them at that point, okay? All right, so we'll be in recess for 10 minutes. Remember my admonitions to you. All right, we're in recess.
Well, I'm kind of surprised that they're not just ending for the day because it's 4 p.m. in Atlanta. But I'm assuming we are just going to hear one defense opening after that, and then they'll end for the day, you'd think. Because, while the court was staying until like 9:30 p.m. during the motions hearing, they can't make the jury do that, can they? But we'll see. We'll see how long the first defense opening is. It sounds like at this point, the judge doesn't even know who's going to give the first defense opening. He was just like, yeah, whoever wants to go first can go first. So it's always interesting to me. One of the first trials that I watched in person had 2 defendants in it with two separate defense teams. And it was interesting to me to try to figure out like how in coherence or how in cahoots the defense was, like if they were working together strategically on things or if they were just doing their own thing. Because it seems like the attorneys could get together for the 6 defendants and argue that they have, who should go first, or it'd be a strategic thing on which defendant would be better to go first or whatnot. I'm not sure, but we'll see here. And yeah, opening statements are usually, the reason this is so long is because we had that big break, but yeah, usually they're this long. And frankly, in LA Superior Court, like the Harvey Weinstein trial, they were longer and they were crappier too. But yeah, usually they're, an hour or 2, and attorneys always go way too long. Like I think they needed to cut that down. Like I saw somebody saying in the comments that this really isn't that like hard of a case. And she's putting way too much like meaningless, like kind of fluffy statements in there when she could have just been stating the evidence. But yeah, it usually goes on and kind of drags on for a while. I saw somebody asking about notebooks, saying that jurors wouldn't be allowed to have their notebooks with them for opening statements in the state of Iowa. I know I'm used to seeing jurors with notebooks all the time in California, but then when I realized when you said that, I'm not sure if they get them for openings. I think they do. But yeah, that was a long one, but I'm kind of thinking we'll just power through. We only have maybe another half an hour to an hour when the defense closing comes up. And yeah, she you can tell that the prosecutor herself, it's Adrienne, I think is her first name, Love, DA Love is her last name, but you can tell she's like nervous about some of her witnesses. Any kind of case like this, you can anticipate maybe some witnesses aren't going to testify right how you think they're going to, that kind of thing. But she was kind of warning the jury about, credibility issues and look for this and that. And if somebody isn't testifying the right way, look at, look at what's who they're looking at in the courtroom. I thought that was kind of interesting. Does it matter that somebody else was already convicted on the Lil Wayne matter? No, I mean, if anything, it helps, because especially like if that person testifies, I don't have any idea like who's actually going to be called here. But in the Mongols motorcycle gang or club, as their lawyers would say, it's a club, Little Angel. It's not a gang. But the Mongols RICO case that I covered in federal court in California like 5 years ago, some of the overt acts involved crimes that somebody had already been convicted of. Actually, there was a Mongol who was convicted of killing a Hells Angel in San Francisco in like 2008. It was like the Hells Angels chapter president, and he was convicted of murdering him in furtherance of a gang activity. So it was a federal inmate, and he testified in the Mongols RICO trial because the murder that he committed and had been convicted of and is currently doing life in prison for was one of the overt acts for the Mongols motorcycle gang in general. The only actual defendant in that Mongols case was the Mongols motorcycle gang, like as an entity, because they actually had trademarks registered to them and patches and everything. So the DOJ, the Department of Justice, was trying to go after their registered patches by getting them declared a criminal street gang through this racketeering case that they could then use to have the patches forfeited. So the jury ended up finding the Mongols guilty of RICO and RICO conspiracy, and they ordered some of the patches relinquished, but the judge actually blocked it under the First Amendment and said that it was unconstitutional. So it was kind of like this big waste of a trial, kind of, but a little different than this one. But the RICO concept is the same concept, the racketeering conspiracy, where you have all these overt theories that make up the alleged conspiracy, and jurors aren't finding guilt or innocence on the underlying acts. They're finding them true, but you could find a RICO conspiracy without finding all the overt acts true. But it'll be interesting to hear who the actual witnesses are for that Lil Wayne thing, because I mean, the way she was talking, it sounds like Lil Wayne could be a witness, but who knows? And I think he's been rumored to be on the witness list, or he's on the witness list, but really the witness list is always just kind of, I mean, they could always not call people who are on the witness list. Like, you kind of want to go on the side of including a lot of people on the witness list, even if you're not going to include them. But I do think we could be hearing from some pretty big people over the next couple of months. Yeah, I do wonder her trial experience, Adrienne Love, because I mean, I can't imagine she's not really experienced. If she's a district attorney and she's on this case, I mean, I can't imagine it's her first trial. But that whole burden shifting comment that she made in the very beginning was just like, what the hell? Like, I mean, maybe it is her first trial. I don't know. I thought that was really weird. So let's see what else. What the chatter is online. I think people are a little fatigued. I mean, that big delay in the middle of it kind of tired everybody out. I know it did me. I might have to sign off here, or just turn off the screen and you guys can just watch the live or something. But I'm trying to find some other stories to do too. There's stuff coming in. There's some guy who's actually, I mean, I know this will have interest online, because this guy was like hacking into Instagram influencers' accounts, like using SIM card swapping to like take over their social media accounts. And the DOJ just issued a news release about how he was sentenced for it. And how much time did he get? There's also another sentencing I kind of want to look into that happened this morning. Some U.S. Marine who was sentenced for like trying to help overseas terrorist organizations, like trying to raise money for them or something kind of weird like that. But there are a couple of sentencings like that I could look into, but I was kind of trying to pull up the notes. Oh yeah, it's this downtown LA SIM swapper sentenced to 8 years in federal prison for hijacking influencer's Instagram account. Of course, when you look into the case, though, because I mean, your first question is who is the Instagram influencer? It says she has over 100,000 followers on social media. Well, so do I. But it doesn't say who it is, and if you look into the file, you don't really see it. But I have somebody at the door, so I'm gonna step out here. Okay, I'm back. Yeah, I did. I saw Rolling Stone had an article back after Gunna's plea deal that he wasn't expected to testify. So he's out, but seems like we got to be seeing some other big names here. Wonder how long they're going to be out here. Brought up this guy is in Atlanta. He's the Atlanta TV reporter who is, I guess, doing some stuff for Law and Crime Network. But it says deputies tell me that they've had to turn away, quote, dozens of Young Thug fans, quote, from the courtroom. It's first come, first serve for fans. If you don't get in, you can watch the trial on a monitor on the 8th floor of the courthouse, which obviously isn't as good, but still. It's a small courtroom, and it seems like they've, with 6 defendants, they've already had to take up some of the gallery room with that. What's up? Get it back on here. So yeah, I mean, this trial is going to become like a lifestyle for 2024. We're all going to be living the lifestyle with the WSL trial. I mean, this was not a good sign for how unorganized they are, but and just the way the prosecutor is so kind of slow, it'll be interesting to see the witness exams. I'm assuming there are other DAs with her. Like, she's not going to be the one. She's not going to be questioning every single witness, is she? But maybe she will. But that's a lot for a trial like this. Usually they'd have like 3 or 4 or something on it. But I'm gonna come back here. Seeing a little movement here. Somebody's in front of the camera. I'm glad my my video of the burden shifting comment is getting some good comment attention on Twitter.
What you will not hear any evidence of is that the defendants were not involved in a criminal street gang.
What?
You will not hear any evidence that they did not commit crimes on behalf of YSL. And as I stated to you earlier, what I'm saying to you now is
Let me object to that statement, please, as burden shifting.
Object basis?
Burden shifting, and under Parker versus the state at 277.
Why don't we take that up then?
39.
I'll note your objection. I'm sustaining the objection. Why don't you rephrase, madam?
Oh.
Yes, Your Honor.
Yeah. There we go.
Ladies and gentlemen,
his instruction to them. I think it's just the Fulton County DA's office, but I might be wrong on that. I mean, we haven't heard anything about the, or at least I haven't heard anything about the AG having somebody in there or anything. Yeah, burden shifting. So it's the burden of proof. It's whose job it is to prove to the jury that something happened. So it's not, it's never on the defendant to prove anything. It's like when they emphasize that the defendant doesn't have to testify, the defendant doesn't have to put on any evidence. It's solely on the prosecution to prove their case. They have the burden of proof. That's why in closing argument, the prosecutor goes first and then the defense goes, and then the prosecutor goes again. And maybe some people would look at that and say, well, why does the prosecutor get to go twice? Like maybe that's unfair, but it's because they have such a high burden of proof. They have to prove this beyond a reasonable doubt, and the burden of proof is on them. And it's a big no-no. And to ever kind of to shift that to the defense, to question like why the defendant didn't testify and all that stuff is like something that's taken like really seriously by the appellate court. Like if the prosecutor implies that the defendant didn't testify and there's something strange about that, that's an issue. It's all about making sure that you're not making the defense prove anything. So when she said that, when she's like, well, yeah, you're not going to see any evidence that they didn't do this. It's like, well, yeah, they don't have to present evidence that they didn't do this. Like it's kind of crazy. It's like we're back here. I wonder who's going to be up. Hope it's somebody good. I bet Brian Steele. I bet Young Thug's guy will go to. Court is back. Yes. I don't know. Maybe like at least 6 months. I think they say 6 to 9 months to a year, maybe. Gosh, just the way things are going. A year, 2 years. We're all gonna grow old here. Go to our high school reunions and still be here. Right. 420. It's 420 in Atlanta. Who's token up while watching the Young Thug trial? I will say, I mean, I definitely prefer being in court for trials, but man, it is easier to cover a trial this way. Although, I mean, the people who are really doing the work at the trial, like the Atlanta Journal-Constitution reporters, that kind of thing, it's just so much different for them actually having. Okay. It's a class, kindergarten. All right, kids. Oh, sorry. There we go.
Okay, all right. Mr. App, what do you need?
Your Honor, my understanding, I planned my opening arguments around
opening statement.
I'm not using any PowerPoints. I didn't.
You're not arguing anything.
Because I'm planning my opening arguments where I'm using just paper and notes to speak to the jury off of, with the understanding that I was going to have a lectern to speak, to put those papers on in front of the jury. And my understanding was from Mr. Steele that there was a conversation with Captain Kendall last week that a lectern, which is in the hallway, would be allowed to be placed up there so that then those papers could be used. I understand now there's some disagreement or understanding about whether a lectern that's out there can be used or not.
I wasn't involved in that particular conversation, but I want to say that also, in order for us to for you to be heard, my suggestion is you probably use the podium. And there's plenty of room on the podium, that particular podium that's immovable. And it's also got a microphone. And you're welcome to walk back and forth, sir. You can walk around the well. I'll give you permission to do so. You won't bother me.
So I can tilt this.
There's
a sign on
do
it.
not move. Do not move. Do not. Yeah, because it's it's part of our evidence presentation system.
Well, there is a lectern on wheels that's 20 feet away from here that if we could just move it into the.
Well, you've also got the challenge of you got some jurors there available. So jurors that are sitting there closer. So I prefer you not do that. Okay. You have to do the best you can with the table you have. Like I said, you can walk around. You can even put some of your stuff on the edge of the state's table if you'd like to. And also related to that, if there's anybody in the media that is zooming in on anything that's involved on any council table, please do not do that. Okay? If you are, don't do it. So just please, I just wanted to make you all aware of that. All right? So, Mr. App, if you'd like to, since all this furniture belongs to me, technically, you are free to put your whatever you need on the edge of the state's table.
Can I use the witness stand when I'm giving my?
Yeah, sure. Absolutely. Absolutely.
I prefer the lectern, but I understand.
Yes, Mr. Sharp.
As a person who spent most of this morning trying to procure a lectern, there's also.
You didn't tell me though, and we could have gone through this earlier.
I spoke to Captain Kendall last week. I spoke to numerous members of the sheriff's department this morning, and I was going through every procedure that I was supposed to go through.
Well, ultimately, it's my decision, right?
I understand.
Okay.
There is a much smaller lectern that can easily be picked up and placed here in courtroom 1D. It will literally take 2 minutes.
Sir, I want to move the presentation of this evidence. We could have discussed this weeks ago, and we could have gone ahead and planned it. I could have brought it over here and test drove it, but you didn't give me that opportunity, so let's move on.
Okay.
All right.
Yeesh.
Anybody else?
Do you know what time?
No,
6 o'clock?
I don't know what time we're going to, but I'll let you know as soon as I'll figure that out in just a little bit, Mr. Steele. Okay?
You think the jurors might want to know?
Who's making the opening statement next? If so. Okay. All right. Let me know when you're ready, sir.
We're just going to set up on Zoom.
Okay. All right. Let me know when you're ready.
Your Honor.
Yes, Ms. Act.
I'm gonna see.
Kokomo is helping me with this.
That's fine. That's fine. That'll work out. And Ms. We will yield some space to you, so, okay.
Being most accommodating.
There you go. We aim to please.
We're getting closer, I think, guys.
Oh, man.
Unbelievable. Like, if this was the courts I cover in California, they end at 4:30. And especially California State Court, everyone is unionized. So they can't go past a certain time. And it's like union overtime rules. But it's Georgia, so they probably don't really have much of a union presence.
I sent them to you. I think. Yeah, I think I emailed the first two to you, but I don't. The second two, Chris, Miss Love's gonna have to send them to you because they're password protected. So if you ask her to send those to you, she can. Yeah, I went ahead. Yeah. You ready, young man?
All right.
I think he said he's ready.
Oh, you ready?
Okay, all right. Can we summon our juror sergeant in, please? All right.
Yeah, it was a little worrisome when the judge was like, "Yeah, I don't know. We'll see." It's like, well, you might be here for a while, I think.
All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. All right, does any member of the defense wish to make an opening statement this time?
I would, Your Honor, on behalf of Mr. Stillwel.
All right, Mr. Sharp, you may proceed, sir.
Thank you, Your Honor. May it please the court. Good afternoon.
Good afternoon.
My name is Max Sharp, and along with my co-counsel, the gentleman with the white hair back there, his name is David Botts. And together, we have the honor and privilege of representing Shannon Stillwel. Shannon Stillwel is an innocent man. He's been accused of the murder of Donovan Thomas in 2015. He is not guilty. He's been accused of a murder of Jamal Drinks in 2022. He is not guilty. He has been accused of conspiring to violate the Georgia State RICO law. He is not guilty. Now, I am going to deliver an opening statement that will preview what I believe the evidence will show in this case and the evidence that will come in trial. But before I even start previewing what I believe the evidence will be, I want to discuss with you some preliminary matters regarding this case. The first preliminary matter that I wish to discuss is my client's name. Okay? On the indictment, you will see, when you look at the indictment, that my client is listed as Shannon Stillwel, also known as Shannon Jackson. Okay, and there's a simple explanation for that. You will learn that his mother was a Stillwel, but he was raised by his paternal grandmother, Betty Jackson. So at times, he's been a Stillwel, at times he's been a Jackson. He's indicted as Shannon Stillwel. I know him as Shannon Stillwel, but throughout this trial, some people may say Shannon Jackson, some people may say Shannon Stillwel. I may slip up and say Shannon Jackson. But we're talking about the same person, Shannon Stillwel. Second preliminary matter. It has not been lost on me that my client, it's not lost on any of us, that my client is charged with 2 murders in this case. He's charged in 2015, and the evidence will show that he was wrongfully accused. And that case never went to court. He was accused in 2022, wrongfully. based largely on assumptions made about the 2015 case. We plead absolutely not guilty. With our backs straight and our eyes wide open, we plead not guilty to those charges. And finally, ladies and gentlemen, as far as preliminary matters, as you probably have realized through jury selection and the fact that we have some visitors from the press here today and different things about this case, this is somewhat of a unique case. It's drawn some attention. But the thing I want to stress is that this case is no different than any other case in the state of Georgia or the United States of America as far as criminal cases go. And it has the same ground rules as any other case tried in this great union. The ground rules of this case are that the defendant, Shannon Stillwel, and all the other defendants are presumed innocent. The state bears the burden of proving their case against all the accused individually. And the state's burden of proof is the highest burden in our system, beyond a reasonable doubt. Beyond a reasonable doubt. Okay, ladies and gentlemen, the state started talking in their opening about about colors and hand signs and different markers and gang activity and all the rest. And I anticipate that the state will attempt to bring in colors and their belief about what colors mean in this case. Throughout this case, I'm going to ask you to focus on a couple colors as well, just to keep in mind as you hear the evidence. Okay, the first color is dollar bill green. Dollar bill green, as you may guess, is the exact shade of green that the U.S. government uses when printing U.S. currency. And the evidence in this case will show that many of these young men grew up without dollar bill green. The evidence will show, and you'll learn about different areas of Atlanta, Capitol Homes, Jonesboro South, places that have since been revitalized in some ways, but back 15 years ago were not nice places. Despair, lack of opportunity, poverty, lack of positive role models. You'll hear about Shannon and his upbringing. You'll hear that he grew up in the Forest Cove Apartments, which has since been condemned. And he was raised by his paternal grandmother, Betty Jackson. He couldn't live with his mother who had succumbed to drug addiction, and it was his paternal grandmother, Betty Jackson, who raised him. She raised him in the Forest Cove Apartments, and you'll hear that she loved him, poured love into him, called him her sweet thing, and he called her mom because she was mom. You'll hear that despite the love and guidance that Miss Jackson tried to pour into Mr. Stillwel, at the age of 14, without other people providing him guidance, he dropped out of school. And he decided that he wanted to be a rapper. You'll learn about the rap industry in this case. And you'll learn, and you probably already know this, but becoming a rapper is not the same as signing up for a job at Home Depot, where you work for 2 weeks and you get your first paycheck. When you're chasing superstardom in the rap game, those paychecks might not come for a long time. And sadly, they may not come at all. It might be a dead end to nowhere. You'll learn about the vast numbers of young men with the same dream as Shannon and how the supply of potential rappers greatly exceeds the demand for superstar rappers. I was really a bad occupation to try to get into when it really comes down to it. But Shannon was 14. And you'll hear how he tried to hone his skills, tried to make it in the rap game. But you'll hear that Shannon, like many other young men chasing the same dream, weren't making any money. And bills have to be paid. And kids have to eat. And rent becomes due. And in this case, and we're not going to hide from it, the chase of dollar bill green turned into a different shade of green for Shannon and many others. That type of green, that shade of green is called bud green, which is actually a color. You can paint your house bud green. But in this case, of course, bud green stands for marijuana. And you'll hear how Shannon, trying to make it in rap, sold marijuana. The state has alleged in their overt acts, okay? These are acts that they claim prove that there's some RICO conspiracy afoot. You'll hear that on August 23rd, 2013, Shannon was charged with possession of marijuana with intent to distribute approximately 1 ounce over 10 years ago. And you'll hear that he pled guilty and did his time. You'll hear that in 2015, in July of 2015, he was charged with possession of marijuana with intent in possession of a firearm. And you'll hear he pled guilty, took responsibility, did his time. You'll hear that in September 25th of 2019, he was arrested and charged with possession of a firearm. And he took responsibility and he did his time. We're not hiding from the fact that Shannon Stillwel has sold drugs. We're not hiding from the fact that he's been found in possession of marijuana. We're not hiding from the fact that he's been found in possession of a firearm, which is always synonymous with selling drugs. Okay. These are his path, his past, his truth, and they were his decisions. His motivation was to make money for him, to live, to pay rent, to eat. Ladies and gentlemen, we're not hiding from the past, but the evidence will show that Shannon's decisions, starting over 10 years ago, had nothing to do with YSL or any other organization. You won't hear evidence that Shannon was selling marijuana and then calling someone from YSL saying, hey, I got some money to support the organization, or calling Jeffrey Williams and saying, hey, I got some money for you, man. No, it was for him. He was a drug dealer. He pled guilty. He did his time. Just like thousands of other people in Atlanta. This has nothing to do with YSL, has nothing to do with the January 10th shooting of Donovan Thomas, and it has nothing to do with the 2022 shooting of Shamal Briggs. On count 1 on this indictment, the state charges Shannon Stillwel with conspiracy to violate the RICO Act. They say on or between January 24, 2013 and the 8th day of May 2022, he and others unlawfully conspired to acquire, maintain directly and indirectly an interest in and control of United States currency and other personal property through a pattern of racketeering. The state in their opening said, further the interests of YSL, further their goals. They also said they endeavored to do a lot of stuff to get them a lot of stuff. Okay, it's a little bit more complicated than that. And in RICO, The actions need to be part of a racketeering organization, not a drug dealer selling drugs to put food on his own table before his studio time to chase his dream as a rapper. I'm going to ask you, as a close of evidence, to find Shannon Stillwel not guilty, count one.
Almost done, it sounds like.
Okay. The other color, besides dollar bill green and I guess bud green, that I'd like to talk about is Fulton County blue. Now, Fulton County blue refers to the Fulton County Jail, 901 Rice Street, where people are taken when they're arrested for felony charges in Fulton County. And Fulton County blue refers to the jumpsuits that these individuals wear, the county issued jumpsuits that are typically navy blue, a deep navy blue, and say Fulton County inmate on the back. You'll hear about the conditions of jail life and Fulton County jail life in particular, and common sense dictates some of this. You're confined to a cell, sometimes with another man sharing that small cell with you. You have no privacy. Use the bathroom in front of men, shower in front of men. You're in fear, danger. You're separated from your family and your loved ones. But most importantly, the men wearing blue, Fulton County blue, they've lost control of their lives. They've lost control of their destiny. Their destiny is now in the hands of the judicial system, in the hands of prosecutors. Ladies and gentlemen, Fulton County blue is going to be a very important color in this case because the state's key witnesses in this case that they're going to call to testify, that I anticipate that they will call to testify against my client Shannon Stillwel, when they became involved in this case, they were all wearing the Fulton County blue. When Mary Zachary, Kenneth Copeland, Sammy Davis, Tremont Stillwell, Spencer Wright will hear them testify, if they're called, you'll hear what they've said previously, perhaps. But what you should keep in mind is, when did these men say what they have to say? Did they say it when they first got the information to share? Or when they claim they first got the information to share? Or did they share it when they found themselves wearing the Fulton County blue? When they no longer had control of their destinies and they needed a favor. And they decided to insert themselves into a high-profile case that could solve all their problems. Okay. Let's talk about January 10, 2015. That's the case involving Mr. Thomas. And the evidence will show that this was a high-profile case. And the reason, and this is not me talking. I anticipate the evidence will show. I anticipate the state's own witnesses, the state's own gang investigators will tell you, not me talking. I anticipate they will tell you that Donovan Thomas was a big deal, that he was a gangman, that he was the leader of the Inglewood family Bloods in Atlanta, that he was high-ranking. And that's what made this case a big deal on the streets. You'll also hear that this case, the shooting of Donovan Thomas, was caught on surveillance video. Now, I'm not going to suggest that it's the highest quality surveillance video, but it was caught on surveillance video. And you'll be able to watch the surveillance video. And you'll see McDaniel Street in downtown Atlanta at about 7:20 p.m. on January 10, 2015. Remember, winter, it's cold, dark. And you'll see a car zoom down McDaniel Street towards Northside Drive, headed northwest, I believe. And you will see and you will hear testimony that Mr. Thomas was with other individuals. What they were doing, I don't know, but he was with other individuals in a parking lot in between two barbershops, one being Mr. George's barbershop and one being Mr. Bernard's barbershop. And you will hear that this car zoomed down this dark street on that January 9th, and it appears from the video that you will see that an individual starts shooting out of the sunroof in the direction of Donovan Thomas and others. And you'll see that surveillance video for what it is and what it isn't. And you will also see how quickly everything occurred that night. A matter of seconds. Detective Thorpe is the Atlanta Police Department detective that was assigned this case in January 2015, and you'll hear that he gathered the evidence from the crime scene. There was no DNA, there was no fingerprints of value. You'll hear that there were shell casings all along the street, but you won't ever hear that these shell casings were linked to any particular gun or Shannon Stillwel or anything else. And there were no eyewitnesses on January 10, 2015 coming forward saying, yes, I was here and this is what I saw. And I saw this person do this. There was none of that. And you will hear that this case remained unsolved. No one had been charged for 9 months and 9 days. On October 19th, 2015, 9 months and 9 days after the Donovan Thomas shooting, a man named Nicholas Robinson was arrested on the streets of Atlanta and brought to Fulton County Jail for various pending charges. And you will hear evidence that Mr. Robinson decided he needed help. He didn't want to wear the Fulton County blue. You'll hear that he contacted the Atlanta Police Department and got in touch with Detective Thorpe. And Detective Thorpe came out and interviewed this Nicholas Robinson. You'll hear what Nicholas Robinson said in this interview, how he gave his vantage point to Detective Thorpe, how Nicholas Robinson said that he was seated at the MARTA bus bench right across McDaniel Street from the barbershops. And you'll hear that Nicholas Robinson told Detective Thorpe that he saw it all, and he saw the people that were inside the car. And he gave names. Nicholas Robinson said, I saw Antonio Sledge. He came out the sunroof shooting. I saw Kenneth Copeland. He was in the front passenger seat. I saw Deamonte Garlington. He was the driver of this car. Quamarvious Zachary, he wasn't there, but he supplied the gun to Antonio Sledge. And yes, I saw Shannon Stillwel, my client, in the back, passenger side, shooting a handgun. So Detective Thorpe, after taking this information from Nicholas Robinson, who just broke the case, created photo lineups. And you'll learn what a photo lineup is. It's essentially 6 photos that contain a picture of a suspect and then 5 what we call fillers. And you'll learn about that. And Detective Thorpe showed these photo lineups. A photo lineup with Antonio Sledge and a photo lineup with Kenneth Copeland. Each person had their own photo lineup just to ensure that Nicholas Robinson could pick these people out of a photo lineup. And Nicholas Robinson did. And he signed his name, Nicholas Robinson, next to the picture of Antonio Sledge and next to the picture of Kenneth Copeland and next to the picture of Deamonte Garlington, and next to the picture of my client, Shannon Stillwel, Nicholas Robinson signed his name and said, these were the people in the car. Ladies and gentlemen, why am I telling you this? Well, Detective Thorpe had two small problems. First, you will see the surveillance video. You will be able to watch the surveillance video and the lighting conditions out there and the fact that there's gunfire going every which way and how fast the car is moving. And you will be able to judge, is it ever even believable that someone could see 4 people inside a car under those conditions? But there was a bigger problem that Detective Thorpe had. You see, you'll learn that during this interview with Nicholas Robinson, it wasn't only Detective Thorpe, there was another investigator there, an investigator Gaither. And while Detective Thorpe was talking to Nicholas Robinson, Detective Gaither was doing some investigation of her own and looking into Nicholas Robinson and who this guy was who had just been arrested. And after Nicholas Robinson picked out all these people, including my client, Detective Gaither had to tell Detective Thorpe a little secret. Detective Gaither had to tell Detective Thorpe, that guy in there who just signed those photo lineups that just helped our case, his name isn't really Nicholas Robinson. He lied to us about his name. His name is actually Spencer Wright. So, case was solved by someone who lied about their name. So, what was Detective Thorpe's solution? Well, this is what the evidence would show. Detective Thorpe completely overlooked the lie about the name. The improbability of a man spotting 4 different individuals in the car moving at a high rate of speed in the middle of the night. He overlooked those things. And he said to Nicholas Robinson, or said to Spencer Wright, yeah, I've come to learn that your name is not actually Nicholas Robinson, it's Spencer Wright. Could you look at these photo lineups again? And instead of writing a fake name, Nicholas Robinson, could you actually sign your real name, Spencer Wright? And Spencer Wright did. So what happened? Detective Thorpe on October 19th, 2015, based on the word of Spencer Wright, the man who had just claimed to be Nicholas Robinson, Detective Thorpe took out warrants for Antonio Sledge, Deamonte Garlington, Kenneth Copeland, and my client, Shannon Stillwel, based on what Spencer Wright said. Okay. Since October 19th of 2015, people have had an opportunity to review some things on this case. The surveillance video that you will see, it's interesting because not only does it show McDaniel Street to catch the incident, but it also shows the MARTA park bench right across from the barber shops on McDaniel Street. And know who's in the know who's in the park bench? The bus MARTA bench across from the barber shop? No one. It was all fabricated. It was all made up. It was all a lie. We've been able to review Spencer Wright's jail phone calls to associates made around that time. All but admitting, I'm lying. I need to get out of here. I'm inserting myself into a case so I can get favorable treatment, so that others get arrested. The state has since dismissed the charges against Antonio Sledge, Kenneth Copeland, and Deamonte Garlington. They continue to push forward against Shannon Stillwel. Why is Spencer Wright so important? Why have I spent so much time talking about someone who clearly lied, who clearly wasn't there, who clearly made things up? Well, Spencer Wright gives us the blueprint. He tells us what to look out for. What was Spencer Wright wearing when he fabricated his story? Fulton County blue. What did he want? What was he in search of when he fabricated his story? Control of his destiny. He didn't want it to be left in the judicial system. He wanted to use something to get a deal. He wanted to take back control. That's what Men in Blue do. Okay. In this case, I anticipate the state will bring 4 witnesses forward. All 4 have certain things in common, as I stated. When they supposedly came upon information that was relevant, never shared it with law enforcement. But once they were wearing blue and they needed something, that's when they came up with their stories. I anticipate the state will call Quamarvious Zachary, ironically, one of the people accused by Spencer Wright. You'll learn that he claims he knew information from January 10, 2015. January, February, March, April, May, never shared this information with anyone. But lo and behold, you'll hear he found himself in custody for serious charges on August 5th of 2015. Then all of a sudden he had a story to tell. You'll hear he gave a second statement to law enforcement approximately a year later, where he was in a room with the gang investigators, with prosecutors, including the prosecutors that were handling his case and had control over his destiny, his future, and his attorney. And you'll hear that he gave a second statement and was looking for a deal. Quamarvious Zachary is no longer wearing blue. Quamarvious Zachary is not charged in this case. He got his deal. You'll hear about Kenneth Copeland. Again, someone ironically accused by Spencer Wright. You'll hear that Kenneth Copeland hates jail more than anything. The problem is, for someone that hates jail more than anything, he does a horrible job of avoiding it. And you'll hear that throughout this investigation, he's repeatedly arrested by Atlanta Police Department and other jurisdictions. And you'll hear 2 of those arrests were on June 10th of 2015 for guns, found in possession of guns. October 28, 2021, guns, found in possession of guns. And he makes it very clear about what he thinks about wearing the blue. But the interesting thing about him is, as you will hear, is every time he's arrested, law enforcement runs out to talk to him. And he goes through the same song and dance about how he'll do anything. Just don't don't make me wear that blue. Kenneth Copeland is no longer wearing blue. And he's not charged in this case. I anticipate you may hear from a man named Sammy Davis who claims he was at the scene on January 10, 2015. January through December 2015, never once went to law enforcement. 2016, never once went to law enforcement. But then in March 17, 2017, when he's in jail wearing blue, law enforcement comes out and talks to him. You'll hear his story. His story about how 2 cars were driving down McDaniel Street, and the first car sent a signal to the second car saying, Donovan Thomas is just leaving the barber shop. as a signal like it's time to shoot. And how the second car pulled up in front of the barber shop and stopped in the middle of the street. Just stopped. And then people started shooting at Donovan Thomas. You'll hear Sammy Davis's story. You'll also see the video. You'll see that there's no first car, second car. You'll see that there's no signal. You'll see that Donovan Thomas wasn't just leaving the barber shop, that he had, in fact, like the state had already stated, been hanging out with friends in that parking lot for quite some time prior to the shooting. And most importantly, you'll hear, or you'll see on the video, that Sammy Davis's claims that this car stopped are 100% wrong. The car never stops. The car drives on by. Bullets flying everywhere. You'll be able to listen to Sammy Davis's story and compare it to the surveillance video and figure out how much value you should give his story. And finally, I anticipate you may hear from a man named Stillwel. A man who curiously claims he's my client's uncle. Not sure what that's about. You'll hear that he claimed to come across important information in January of 2015. And he claimed he came across this important information while talking to someone with his wife, Yak Gotti, right there. You'll hear throughout all of 2015, never said a word to law enforcement. Wasn't until March 22nd, 2016. Guess what color Stillwel was wearing at that time? You got it. When he was in jail for serious charges, and he needed help. He needed help from law enforcement to start to reclaim his destiny, control over his life, to escape the monotony and the filth of the Fulton County Jail. And you'll hear that he claimed to have information. You'll hear that the state, to their credit, went to try to corroborate whatever Stillwel was talking about and talked to his wife, who is now deceased. Her name is Yak Gotti. She is now deceased. But you'll hear that she was interviewed on May 11th of 2016 when she was still alive. And you'll hear what she had to say about Stillwel's claims. That what he's saying happened, never happened, A, and that Stillwel is a effing liar. Those are the state's witnesses in this case. Those are the men in blue. Count 2 of this indictment is the count that charges my client, Shannon Stillwel, along with a whole new group of individuals with the murder of Donovan Thomas. There will be no forensic evidence, there will be no ballistic evidence. There will be no eyewitnesses that presented themselves at the scene and say, I saw this occur. The surveillance video will not give insight as to whether Shannon Stillwel was there or not. The state's case will rest entirely on the word of men in blue. When the evidence is done and trial is done in this case, I'm going to ask that you return a verdict of not guilty to count 2, murder. Okay.
All right, are we done?
Now, I would like to preview
Not quite.
a little bit about my client's life after the Donovan Thomas murder. Remember, on October 19th, 2015, the Atlanta Police Department, Detective Thornton, and the news broadcast to the world, and more specifically to the streets, and more specifically to the Inglewood family blood gang that Donovan Thomas was the head of, that my client was responsible. Based on the word of Spencer Wright, based on the word of someone that even the state is saying lied. First they said wasn't completely accurate. No, it was a lie. Based on that, they broadcast to everyone that my client was responsible. And there has been repercussions. You'll hear in 2015, people pulled up to my client as he stood outside a store, shot a gun at his head, and grazed his forehead. Thankfully, he's still with us. You'll hear that later in 2015, my client went to go get a fish dinner with the mother of his child and another young lady named Tiara Jones at JJ's Fish at the corner of University and Pryor. And members of the gang spotted them there, stalked that car, drove behind the car, and unleashed bullets upon that car, hitting that poor lady, the driver, Tiara Jones, in the face, killing her, causing the car to crash and spin, breaking bones in my client's body, collapsing his lungs. The streets have not cared that Spencer Wright is a liar. Since that time, my client's life has changed in some small ways and some big ways that I've made sense. Shannon Stillwel, since that time, has been careful about his surroundings. He tends to back into parking spots. He tends to run red lights at intersections, not to be a sitting duck for IF gang members or anyone else. He habitually changes residences. And yes, he does habitually rent cars, including a white Audi. He does this, the evidence will show, so no one can associate him with any particular car. None of the IF gang members can know where he is. And yes, when he rents cars, he does tint their windows, so no one can see in. That's the life he leads since 2015. And yes, when he leaves the house late at night, he does conceal his identity. It was during COVID, but he does wear a mask. That's been Shannon Stillwell's life since 2015. And I'm going to ask that you keep that into account as you consider the evidence as it's presented. Now, 7 years later, March 14, 2022, remember, Shannon has been publicly accused, but no one has ever taken that case to court. No one has ever even tried to actually prove the case. They just accused the case. And Shannon has remained a wanted man. Not by the police, but by someone scarier. On March 14, 2022, the evidence will show that Shannon, Quamarvious Nichols, Meghann Garlington, and Miles Farley were planning on going to the music studio to work on music. Still chasing it. The evidence will show that Mr. Garlington was a passenger in Mr. Stillwell's and Shannon's rented white Audi with tinted windows. And Mr. Nichols was with Mr. Farley in Mr. Nichols' white Ford Fusion. The evidence, and you'll see, in this case, you'll see there's several different surveillance videos that you'll see in this case. The first being the BP footage. That's from the BP at the corner of Fulton Street and Windsor Street. in Atlanta. And you'll see the video. And you'll see Mr. Stillwell. No, we will never deny that he was at the BP. We will never deny that. We'll never deny that he was in a rented white Audi. And you'll see Mr. Stillwell pull up on that camera and back into a parking spot right in front of the BP. And you will see Mr. Nichols shortly thereafter in his white Ford Fusion pull up at the gas tank so he can purchase gas to get to the studio. You'll see footage from inside of the store. That's Mr. Nichols. You'll find out that that's Mr. Nichols purchasing an item, and that's Mr. Stillwell, my client, wearing a Pink Floyd hoodie with a pink wool cap on. And you'll be able to observe them on video, and you'll see Miles Farley, a third person in their group, a shorter individual, come in, and you'll see them playing around and pushing each other in a playful manner as friends do. I'm going to ask you to observe them on a video and ask yourself, does that appear to be men on a mission? Or does it appear to be friends just playing on going to the studio? The video will reveal that at some point, a gentleman by the name of Shamal Drinks pulls up in a red car at another, and in fact, I believe that's a picture of it right there at that gas pump. And he enters the store. You'll be able to see the video of him entering the store from the parking lot, and you'll be able to see him inside the store. You'll see that he gets into some sort of argument or altercation, not an altercation, an argument. It appears with the clerk, and he leaves the store, and he gets in his car. There will be no interaction whatsoever between Mr. Drinks and my client, Mr. Drinks and Mr. Farley. Mr. Drinks in the parking lot, take a right on the Winter Street. And that's where the FedEx surveillance footage will take over. And you'll be able to watch the FedEx footage on Winter Street, which will show these cars drive up and end up at a red light. You will see my client's car.
Wrap it up, dude.
Audi, run a red light. You will see Mr. Nichols follow my client's car and run a red light. Eventually, cars come in to replace him, and traffic flow continues and continues for several minutes. And eventually, a man who's just happened to be going the other way looks into Mr. Drinks' car, which is still sitting there, and notices that Mr. Drinks has been shot. What you will not see on this video is any indication at all that this shooting occurred while my client's car was beside Mr. Drinks. You will not see any muzzle flash, you will not see any commotion, you will not see any fight, you will not see anything at all that suggests that that's when the shooting occurred. So this March 14, 2022 case, what I anticipate is you will not hear any eyewitnesses say that Shannon Stillwel. And let's be clear, the state is accusing Shannon Stillwel. I mentioned that there's 4 people in this party. They are accusing Shannon Stillwel of shooting Mr. Drinks out of that white Audi. The state will not present to you any witnesses that saw this occur. The state will not present to you any forensic evidence that proves that this occurred. The surveillance I submit to you, and you'll be able to see and judge for yourself, points to the exact opposite, that the shots did not come from Mr. Stillwell's car, nor did, and I'm not suggesting they came from Mr. Nichols either, they came from neither car. So why was Shannon Stillwell arrested? Well, they had video of Shannon at the BP. Okay, that's fine, we don't deny that, never will. They made certain assumptions about what would be on that FedEx video that you will be able to look at and determine what it shows and what it doesn't show. And I'm sure they assumed that it was show some shooting, but it doesn't. And finally, they made assumptions about Shannon Stillwel. Remember what the state said in opening about how Detective Hogan had his case. And he had people on a video at the DP, which is near where the shooting occurred, but not where the shooting occurred. He had people on his video, and then he talked to another detective, Viverito, and Viverito said, "Oh, that's Shannon Stillwel. That's Shannon Stillwel. Oh, that's Quamarvious Nichols." And they just ran with it. Yeah. Shannon Stillwel was at the BP that night. He didn't shoot Shamal drinks. None of his friends shot Shamal drinks. They went to the studio. Since these warrants were taken out for Shannon Stillwel, and I'll tell you the warrants were taken out and Shannon Stillwel was arrested in that same white Audi on March 17, 2022, 3 days later. Since those warrants have been taken out, some other information has come forward. First, I'm going to ask you, and you will, this will be entered into evidence, I'm going to ask that you consider the rental agreement for the white Audi. You will learn that on March 16, 2 days after this alleged shooting, when every other person who has a guilty conscience, anyone who has a guilty conscience is trying to get out of the rental car, Shannon extended his lease. I'm going to ask you to consider and really think about that. Extending a lease of a car that you supposedly just killed someone. Are those the actions of someone who's guilty of that crime? You're going to hear about the wiretap on Deamonte Garlington's phone. Remember, Deamonte Garlington was in Mr. Stillwel's car. And the state hinted at it a little bit. They were talking about Jade and Myrick and people wanting to attack a man named Lucci. And based on these concerns in the jail, the state applied for, and you'll learn what a wiretap is, they applied for a wiretap and received a wiretap for Deamonte Garlington's phone. The phone of the person who was with Shannon Stillwel on March 14, 2022. And you'll learn what a wiretap is and how a wiretap really consists of law enforcement sitting and listening in on all your phone calls, incoming and outgoing, and recording all the relevant and pertinent phone calls and conversations that occur. You'll learn that this wiretap on Deamonte Garlington's phone began on March 10th, but certainly well before March 14th, the date of the Shamal drink shoot. So it was in place that night. Who knows about the wiretap? You'll learn that too. Do you think the government tells you that your phone is being wiretapped? Of course they don't. It's secret. No one knows. That's the point. And you'll learn about who Deamonte Garlington is and what type of guy he is. I would submit, if you have a secret, you wouldn't want to tell Deamonte Garlington. You'll hear him on the wiretap, drunk, high, talking about everything under the sun. Pills, weed, guns, girls, robberies, all stuff that he's involved in, completely against his interests to discuss, but he doesn't know he's being listened to now.
Uh-oh.
But one thing that's interesting, of all the things that this loudmouth talks about, all the crimes, and the state said they bragged about this stuff. State said Deamonte Garlington was bragging about this stuff. All the things they brag about, no, it never comes up. Shooting anyone on March 14, 2022. All the crimes he discusses, that never comes up. Finally, and most importantly, the science about this March 14, 2022 case. We're going to learn about gunshot residue. gunshot residue testing that tests for microscopic particles that contain a combination of lead, barium, and antimony. Particles that come from the explosion of a gun and the gunshot primer that causes it. Synonymous with a firearm that has been fired. Who does gunshot residue testing? Georgia Bureau of Investigation, APD, all sorts of agencies to build cases against defendants. You'll learn how gunshot residue is collected. How you take a surface or a body part or an object, you take these adhesive stubs, these official gunshot residue kits, and you dab the surface of an item as much as you want. You can use multiple stubs. And then you take these stubs and you place them under an electron microscope. And a scientist can look under this microscope and see if there's any particles of gunshot residue that are on said item.
He does not need to be explaining this right now.
You'll hear that Shannon Stillwel was arrested on March 17th in that same white Audi that he was in on the 14th. And you will hear that the crime scene technicians, in this case, made a specific decision to pick the best place on a car to test for gunshot residue. When the gun is fired, the gunshot residue would plume upwards. And so they take the best part of the car, the headliner. And for all of you that don't know what the headliner is, that's the cloth top of the car, as pictured right there. You'll hear about Alexander Coven, a scientist, a man in search of the truth, a man who works for GBI, not for me, not for Shannon Stillwel. And you'll hear how that headliner that was collected from that white Audi on March 17th was brought to Alexander Coven at the Georgia Bureau of Investigation. You'll hear he's an expert in gunshot residue collection and analysis and detection. And you'll hear how Mr. Coven, as he was trained, took that gunshot residue kit, took those adhesive tabs, and dabbed that headliner again and again and again and again and again and again, dozens of times. And then he wanted to make sure what he did was sufficient. So he took a second tab, adhesive tab, a fresh one, and continued to dab that headliner again and again and again and again and again to pick up any particles that would be on the headliner from that white Audi. And he took those tabs, those adhesive tabs, and he put them under his microscope that he uses when he's building cases for the state. And he looked at those tabs under that microscope for any particle of gunshot residue.
Okay, this is way more detailed than me.
15, 10, 5, 3,
Dude.
1, whatever he could see.
Sum it up.
You'll hear that on June 3rd, 2022, 77 days after the state,
Oh my God.
Detective Hogan, Investigator Viverito, and the state made their decision that Shannon Jackson fired a gun, Shannon Stillwel fired a gun from that white Audi. 77 days after they made that decision, you'll hear that scientist Coven released his report. Now, on that headliner, there was not a single, zero gunshot residue to be found. That's the science. Ladies and gentlemen, regarding the March 14, 2022 case, the state has made 5 charges, 5 different counts against Shannon Stillwel, my client. First, is count 49 on this indictment. It is murder, alleging that he shot out of the white Audi his child, Jamal Drinks. The science belies those accusations. I'm going to ask you to find Shannon Stillwel not guilty of that count. Now, count 50 and 51 deal with violations of the Criminal Street Gang Act, Gang Activity Act, and they are essentially charges that say that Mr. Stillwel committed murder to further the interests of YSL, and he committed murder on behalf of YSL for the purposes of increasing his standing within the gang. Y'all are smart people. Obviously, I don't need to say it, but it'll make me feel better if I say it. If he's not guilty of count 49 murder, he cannot be guilty of count 50, and he cannot be guilty of count 51. Counts 52 and 54 similarly charge Shannon Stillwel with possession of a firearm by a convicted felon on March 14th of 2022 on the belief that he used a firearm to kill Jamal Drinks. If the state does not prove that case beyond a reasonable doubt, he cannot be found guilty of count 52. And in count 54 charges Shannon Stillwel with possession of a firearm during the commission of a felony, that felony being murder. Obviously, if he didn't commit the murder, then he cannot be in possession of a firearm during the commission of said felony. In conclusion, my client has been charged with 2 separate murders.
The best
He's
words
been
we've heard all
wrongfully accused of 2 separate murders, and we plead absolutely not guilty. He's been charged with conspiracy to violate the RICO Act. And while now he has sold marijuana in the past, those were his decisions for his benefit and had nothing to do with YSL or anyone else involved in this case. He's pled guilty to those charges. He's done his time. That makes him an ex-drug dealer. It doesn't make him a conspirator. It doesn't make him guilty of violating any RICO acts. The ground rules. Shannon Stillwel is presumed innocent. The state bears a burden of proof, and the standard of proof is beyond a reasonable doubt. I believe in this case, if you focus on where the state's evidence comes from, you will find that primarily it comes from the stories of men wearing blue. I'm going to ask you to focus on things like science instead of stories. Compare the credibility of a scientist like GBI scientist Cole, who followed all the rules and determined there was absolutely 0 gunshot residue in that outfit. Compare that to what the state presents. Spencer Wright, who said his name was Nicholas Rodalius, who lied, get out of jail.
All right, dude, you're done.
Spencer Wright duped Detective Thorpe on October 19th of 2015, and that is on Detective Thorpe. I am going to do my best to make sure that the truth comes out in this case. Make sure that no one wearing blue will be able to dupe anyone during this trial. My client, Shannon Stillwel, is not guilty. Thank you very much.
Right, we're done. Okay. End it for the day.
Ladies and gentlemen, how you doing? It's 5:30. All right, consistent with my earlier promise to see you, I think it might be a natural stopping point for us to put a pin in today.
Yeah.
And for us to come back to more, unless you all object to my suggestion. Hearing no objection, I think we're going to go ahead and do that. So let's go ahead and kind of review a couple of things to begin with. All right, first thing is when you go back into your headquarters jury deliberation room, dump your notepads, okay? Hopefully everybody's written their name in the inside cover of those freaking ones like I told you earlier. But if you haven't done so, go ahead and do so. Take a juror sticker and put it in your pocket, your purse, or whatever carrier device you have, so that when you come back in tomorrow morning, we'll go ahead and you can put that on as soon as you get into as you come in through the being screened in the courthouse, okay? All right. You've kind of figured out already for tomorrow if you need, and I think I mentioned to you this earlier, a lot of you wearing jackets and everything else, it's easier, like I said, for you to put on a jacket or for you to take off something than it is for me to kind of regulate the temperature. So please bring whatever it is that'll make you comfortable tomorrow, your jacket or otherwise. Okay, that's kind of the ministerial. And if you're running late tomorrow, as I mentioned earlier, let Ms. Umana know. But remember, I can't start until I've accounted for all 18 of you. So it's very important you, again, as I mentioned earlier, only you know how long it takes for you to get down here to Fulton County from wherever you live in our great county. So just plan accordingly, leave a little bit earlier. It's always easier for you to sit back there and just kind of relax and don't be so stressed than it is for you to kind of leave late, and that just kind of just puts you in kind of a position you probably are stressed already when you get here. So I'd advise you to do that. Okay, you remember all my ad nauseam admonitions? They still apply, okay? So very important, I mean, that you not talk about the case amongst each other as you're walking out. Do not talk about the case as you're in your headquarters to your deliberation room. Don't go on any social media sites. Do not let anybody friend you. Do not do any of the other things that I told you earlier, like research anything, go by any scenes, take any photographs, or otherwise try and educate yourself to some things that you may have heard in the courtroom today. Remember, the only things you can consider are what's lawfully presented within the four walls of this courtroom. So it is very important that you consider and keep the court's admonitions, which I know you will continue to do so. There is great temptation when you go home tonight. Hey, what happened in court? Well, I saw you on TV. Are you supposed to respond to that? No, you're not. And you can blame me. You can even tell Judge Glenn said for you not to do that, all right? Because remember, your doing that would affect, and if we found out about it, would affect our ability to have a fair trial, a just trial, lawful trial as to all parties. So please adhere to that admonition and all the others, okay? Remember, nobody's supposed to have any ancillary or incidental contact with you. If anybody tries to reach out to you, I need to know about it so you can tell Sergeant Ingram or any of my team if anybody should try and do so, okay? And consistent with my instructions when you were here before, we'll go ahead and get you squared away for those of you that are taking the shuttle and for those of you that need to make other alternative arrangements. We have just get with Sergeant Ingram. He'll go ahead and coordinate that for you, okay? All right, so you're probably wondering, what time are we going to start tomorrow morning? I need you all here to be here by 10 o'clock, okay? We will start somewhere between 10 and 10:30 tomorrow morning, and I'll do that, try and give that to you every single night that we conclude, tell you what time in the morning you need to come to be here. That's your target or mark time you need to be here in the morning. Try and get here a little bit earlier because then, like I said, you'll be a whole lot more at peace. And then as soon as at 10 o'clock or thereabout, I can find out if all 18 of you are here and I don't have to look for anybody. And then I can go ahead and we can get started once we're ready to pick up from where we left off from today. Okay, so 1,000 hours tomorrow, you need to be in your headquarters. Okay, I think I've gone through all the things I need to with you. Any ministerial inquiry of me at this point in time, ladies and gentlemen? Anything from me? Questions? None? Okay. Ladies and gentlemen, thank you for your patience with us. And as I mentioned earlier, and I mentioned through this entirety of the process, the patience that you've given us are giving us today and will continue to give us throughout the consideration of this matter. So unless you have any other query or questions for me, I will release you until tomorrow morning and bid you comfort. And we'll see you in the morning. We'll start up when you all get here at 1000 hours. Okay? All right. So with that, ladies and gentlemen, have a good evening. All rise.
So I quickly learned watching trials that you got to stick around. Because a lot of people who don't watch trials and this happens, they think it's like, oh, we should go, which, yeah, you can, this testimony's over. But as soon as the jury leaves, they're going to talk about a bunch of stuff. Maybe not a bunch of stuff.
Okay. You want to pick them up the front?
Okay, ladies and gentlemen, please be seated. Our jury has left us and the door is closed. All right, so counsels, tomorrow morning, first, before I go ahead and set the time for you all to be here tomorrow morning, Mr. Harvey, sir, have you talked with counsel for your client? Your client's spouse, I should say.
No, I haven't actually, and I will try to contact her. She was flying back into South Africa on Monday, so I did try to contact her. I'm going to do that right now.
All right, if you could ask her to be present for at minimum 9:45-ish tomorrow morning, I'll take it up somewhere between the 9:45 and 10 o'clock time period, and I can go ahead and get that done, or you can have a conversation with the state and I can final that particular ruling, okay? All right, okay. So counsels, if you all could be here tomorrow morning for approximately 9:30, and as I told our jurors, as soon as all of them are accounted for and we take up that last issue, then we'll go ahead and get started. What questions do you have of me? Anybody?
On behalf of Mr. Williams, sir.
Okay, so Mr. Steele, you have yet to make an opening statement, is that correct?
Correct.
All right, Mr. Matthews, you have not made an opening statement as of yet?
That's correct.
Ms. D. Williams, you have not made an opening statement as of yet, is that correct? All right, is there anybody else that I have not taken into account already? I'm sorry? It's just going out, that's all. You know. Yeah, it's kind of giving up on me today. I don't know what's happened to it, but yeah. Anyways, Mr. App? Okay, all right. So we'll start tomorrow with that, and we're going to anticipate after we complete opening statements, stating you're prepared to call your first witness?
Yes.
Okay. All right. Any other inquiry of me at this point in time? Okay. Hearing none then, folks. Appreciate your patience and diligence. I'll see you all tomorrow morning for an anticipated 10 o'clock start time. Please try and be here by 9:30, and then we'll go ahead and I'll take up Mr. Harvey's matter, and we'll go ahead and get started, okay? All right, we're in recess.
Thank you, Your Honor.
All right, you're welcome.
So yeah, there we go. That was a long day in court, and it looks like we're back for another one tomorrow at a 10 a.m. 7. I got it off mute, guys. So back at 7 a.m. my time, PST. So I think I'll be back then. That was a long day of opening statements. I thought it was a real fumble by the prosecutors, and that was a strong. I mean, it went on for too long, but obviously they've got a lot of material to work with on the defense side, and we're going to be hearing, I think, 5 more of those. It sounded like every single defendant was going to be doing a defense statement, so I didn't hear if they did say who's up first tomorrow. I didn't hear it, but I imagine we'll be hearing from Thugger's lawyer sooner than later. Because I just can imagine being the 6th defense lawyer to get up there and give a defense. It's like give an opening. It's like, even if you're planning on giving an opening statement at that point, it's like you might have lost the jury and you just need to go on. But yeah, it looks like there's so much to unravel here, and so many different overt acts and so many different witnesses that are going to be coming up. It's like, it really wasn't a good sign for the prosecution that they kind of fumbled so early in their opening statement, because you'd think they'd be a little more organized than this. But, it's such a long trial that in 6 or 9 months, are jurors even going to remember the opening statements? It could kind of cancel out later on. But yeah, it should be an interesting trial to watch. I mean, I don't know how much of it I'm going to be covering day in and day out, but I do plan to watch the rest of the defense openings tomorrow. So we'll see if we can get this live stream set up again. I thought it worked pretty well. I wasn't totally sure I was going to just have the live stream on all day, but people seem to like to tune in and answer questions and ask questions, that kind of thing. So maybe we can do that tomorrow. But just given my work schedule and some of the other cases I have going on, I don't think I'm going to be doing that like every single day. But I am going to be going on Scripps News tonight at like 6:30 p.m. I'll tweet it out, but it's a streaming service. When I turn on my YouTube TV, I can see it as an option on there, but it's Scripps News TV. So I'm going to be talking about the Young Thug trial. So that'll be a good summary clip that they'll let me post on my YouTube. So look for a notification or subscribe to my channel to look for that clip later on, because I think we're going to be able to talk for like a few minutes. So we should be able to do a pretty good summary of everything that just happened. And then it looks like Wednesday morning, I think I'm going to go on CBS Chicago and do a quick summary too. So you guys can check it out then, but it'll be a good chance to kind of go over everything and sum it up. But obviously they've got a lot to prove here, and a lot of the prosecutors do, and a lot of defense attorneys to contend with. And I mean, just the way the prosecutor was kind of warning the jury about the witnesses and how we don't know how everything's going to testify. And, if they're nervous up there, look at who they're looking at in the courtroom. I think we're definitely going to be witnessing some dramatic moments on the stand, maybe people not testifying quite the way that prosecutors hoped, that kind of thing. So that'll be fun to see. So yeah, somebody says I'm Pinky Blue says I'm booked and busy. Yeah, I am. I like it. I like it. Got to keep it coming. So we'll see how this YouTube live thing hashed out for later on. Because if it's worth it and people are tuning in, I'd like to do this for like big trial days that I'm working from home and stuff. I mean, who knows if Lil Wayne is actually going to testify, but he's, on the witness list. And I guess he's been, rumored for a while. I mean, we heard the clip about the shooting of his bus, which I guess when I Googled it, that was back in 2015. And there were a couple people arrested and there's a lawsuit over it. I mean, it's been like widely publicized, but it was kind of funny to hear about the victimization of Lil Wayne in this trial. So thank you everybody for tuning in, and I will set this up for tomorrow. I'll try to get the link up tonight, and you guys can check it out. And be sure to check out my Scripps News clip when I post it, because if you guys give it a like and spread it around, it might help the algorithm and get it going, get it some juice. So thank you guys, and have a great Monday night. See y'all later.